2023. However, it's not being listed by the department. So I was just praying for the inclusion, subject to your lordship.
Come on Monday, mention on Monday, because I already informed the bar. A testamentary matter mentioning come on Monday.
Very well, your lordship. Grateful.
May I be permitted to mention, my lord, item 87 of my lord's list, my lord, of the commercial list. My lord, I'm mentioning this matter, seeking to have this matter included as to be mentioned. I'll indicate why. My lord, at
87.
87 of the commercial list, my lord. My lord, this is a matter where my lord had passed an order directing the defendant to set apart a certain sum of money upon contested hearing. The defendant had filed an appeal, the appeal got dismissed. Thereafter, my lord passed this order. May I hand up a copy? My lord directed them to file an affidavit of compliance to show that they have complied with my lord's order. Thereafter, my lord, they sought an adjournment on that date. Again on 24 January 2025, again an adjournment was sought with a different set of lawyers. Thereafter, the matter hasn't been called. It was appearing under the heading adjourn motion throughout. Now it has somehow appeared in the list of suits under the commercial list, my lord. But since 24th, my lord, the matter hasn't been called, my lord. I'm only seeking to ensure that my lord's order is complied with, my lord. My lord had passed these directions. It's been not been complied with. No affidavit has been served upon my client, my lord. Could it be included as to be mentioned on Monday, my lord? I'm humbly beseeching, my lord. Thereafter, my lord. Yes. After this, it wasn't called, my lord.
Yes.
My lord, I'm only humbly beseeching that the matter be placed as to be mentioned, my lord, so that at least they can apprise, my lord, of what steps they've taken. There's an order, subsisting order.
If they are not taken, you take appropriate steps. What
My lord, could it be
done?
only be included as to be mentioned on Monday, my lord?
Why?
My lord, because that direction, my lord, today if I take out an application.
They have not complied with, you have
I understand.
another way.
I understand, my lord.
You take steps.
My lord.
Lord, may I be permitted to mention, my lord, one matter, non-commercial matter, my lord, running in the list, my lord, as item number 28 today. My lord, this is for presentation of plaint, my lord. There is some urgency, my lord.
28 today.
My lord, in the non-commercial list, my lord.
Non-commercial list today, it will not be taken.
Yes, my lord. In that case, my lord, if it may be taken up, my lord, at any point, my lord, on Monday for 5 minutes, if it may be taken up, my lord.
Why you not mentioned tomorrow, yesterday?
My lord, I have just been told today, my lord, of this matter.
No, non-commercial presentation of print. What is the urgency?
My lord, I have been told, my lord, that the...
I'm sorry, my lord, my friend was filling in my place. My lord, the urgency is that this is a suit for declaration, delivery up, and cancellation. My lord, my property has been sold without any consent or concurrence of mine. The urgency is this, my lord. We have come to learn from reliable sources that they are taking steps of filing a separate suit in a court that does not have cause of action. My only apprehension is this, my lord. Going to section 10 of the Code of Civil Procedure, this suit would be barred because that suit will be initiated prior. This is the only urgency, my lord. I must be a candidate before my lord. He was praying for my lord's kind indulgence to take up the matter any time, subject to my lord's list for 10 minutes.
When the matter was listed, why you are not mentioning in?
Here we took a chance when my lord's list is so heavy. We did not want to disturb my lord's list, my lord. It was appearing as item number.
Non-commercial, how the matter? Come on Wednesday. Come on Wednesday will be taken.
Seeking my lord's kind indulgence for 5
How?
minutes. I appreciate, my lord.
You give the suggestion how in the commercial list how the non-commercial matter will be taken for the presentation of the plaint. What can be done?
Oblige, my lord. I was praying for leave on that count.
May I have your lordship's leave to mention letters of administration matter in the citation has to be issued.
Already, every time I have to mention, come on Monday. All PLA matter come on Monday, if any urgency.
Item number 1.
In view of the above, the department is directed to return the plaint along with the documents to the plaintiff by keeping the copies of the same for the purpose of record. The plaintiff is liberty to file appeal before the appropriate court.
Grateful, your lordship.
Contempt Matters, item number 2.
Well, this is my application. With due respect,
Lordship, I am for the applicant, Your Lordship. The
Yeah.
contempt application. On the last occasion, Your Lordship directed for the personal appearance of the contender number 1 and 2. The rule has been served, and I hope, Your Lordship, the learned advocate for the other side, Your Lordship, is also present. But, Your Lordship, I could not find, Your Lordship, the contender number 1 and 2 be here personally, Your Lordship.
Good. There was a direction, Miller, on the last order that to take steps for service notice upon the contender number 3 that we have duly served, and this is the affidavit of service. May I file?
Even the contender number 3 has also been served, Your Lordship.
Yes. Who is appearing for the contemners?
So for the contempt number 1 and 2 is concerned, my lord. My lord, I am appearing in this matter, my lord. My lord, so far the personal appearance party is concerned, my lord. He is approaching the High Court and he was fallen ill in the grounds chair. He is coming within 1 or 2 minutes, my lord. Just
Okay, pass over.
my lord, just pass over. Lord,
Pass
so that
over.
your lordship can-
Lordship.
The matter is appearing today for may I
Yeah,
file?
if Mr. Raichodhuri can share his written notes with
Already
us
given.
also. I have shared mine. And my lord, the judgment I had relied on, the Bengal waterproof, I'm just handing over my advocate on record, just hand over a copy. Because Mr. Bachawat had argued that no leave was given by the Delhi High Court. My lord, passing off on an infringement action is a continuing cause of action. And Order 23 also does not apply.
Lord, this judgment doesn't say Order 23 does not apply.
It talks about order to rule 2, but it also talks about it's a continuous cause of action.
Order 23, man. And this
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Yes, Mr. You have filed that written note?
my learned
we
friend
filed
filed
yes,
it.
yes, on the previous lordship.
Counsel for the defendant has
I'm
filed
fi-
the written notes of argument.
Yes, ma'am.
After serving the copy to the London counsel for the plaintiff, let the same be kept in the record. TAV. Interim order till which date?
Till today, lordship, till today.
The interim order granted is extended till the disposal of the present application.
Grateful, my lord. Grateful.
I was hoping your lordship wouldn't ask interim order till which date. I was hoping you wouldn't ask interim order till which date.
5, 6 and 7 are 3 connected suits, my lord, where
Yes.
our temporary application and the plaintiff's application for amendment. My lord, 3 suits, so we have filed 3 notes, essentially the same.
We are for the
Essentially the same
plaintiff.
thing
We have
because
filed
the
one
defendant-
composite note because it's the same
In
point
all.
of law involved.
In all matters.
No, my lord. In the first matter, my lord, we are filing the notes of argument. We have also stated that we adopt the submissions.
Correct.
One composite note will do, my lord.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Counsel for the respective parties have filed their written notes of argument. Let the same be kept with the record. CAV.
My lord,
Take that.
kindly permit me to make 2 handwritten corrections regarding the suit number. I'll just.
Correct.
Grateful.
Yes.
But only, only one thing, we had not annexed our judgments because your lordship had been
take it away.
working. So, is it your lordship's pleasure that we?
No, you have given the judgment.
Yeah.
Then no problem.
But we have annexed the judgments in.
Okay. If it is annexed, it's okay. If you have,
Should we exchange the notes? Then
yes, exchange.
No, এখন
ও তো দেবে না।
হ্যাঁ দেবে আমি দিতে পারি
Grateful.
দুটোতে করেছিস সে?
Submitted that, corrected.
May it please, man.
Yes.
This is that issue about whether the documents can be shown.
Yes.
I'm sorry, my lord, on the last day I was not there, but
Yes.
if my learned friends have finished their argument,
Yes.
my lord, if my lord sees the document, the original document, your lordship had asked for production. It's been brought. Exhibit 1. Give me a copy. I will just simply see the document. 5 documents have sought to be, copies were given to us by your lordship's officer. My lord, may I just once see the document? Is it written in pen
Hello.
directly? because we have got photocopy. Yes. These ones are all cyclostyle. The stamp is original. It's a cyclostyle document. Now, my lord will see, just taking the first document, your lordship will see the number on the top left, GR number, NICPL 002. Your lordship finds that?
Yes.
And the weight to 25.120, your lordship finds in the second column. Weight, no, the second column.
24.650.
Yes, whatever those
Lamb
are the two questions that were asked to my witness. What is the truck number? What is the weight? He answers those. Now those questions are being shown to say that the witness has admitted the document. Well, that is not, first of all, an admission. He has been asked. And in answer to 295, straight away I'll say the last question, your lordship just sees 295. Mr. Beriwal, I put it to you that the plaintiff had deliberately deposition of copies.
I'll give my copy.
Oh, it's with the registrar, with the commissioner.
But if I need to address, I will need.
I will take mine.
292.
295. The last question.
Yes.
I put it to you. It should be. I put it to you. I put it to you that the plaintiff had deliberately not brought on record the bill cum challans in respect of the consignment summarized at page 77 of the judge's brief. As perusal of the bill cum challans in respect of the consignment would disclose that several trucks in respect of such consignments were rejected by the defendant and returned to the plaintiff.
Yes.
I disagree. There is no proof as to whether the goods were rejected or the trucks were returned. And there is no communication with regard to the same either. And the plaintiff for the first time came to know about rejection of goods when the written statement was filed. There is no correspondence regarding the same. So this document, now I'll just very briefly, 283, my learned friends have asked them and asked the witness, there are 3 consignee copies. When this document is, which is issued by Lucky Coke manufacturers, when I give the delivery, I get a copy, that's A copy remains with the transporter, B, and a copy is given to the buyer, that is C. Now, as far as the document A is concerned, I wrote that we have disclosed the bunch of documents, it's there. But I had luckily given the page numbers in my affidavit. Those page numbers, my learned friends could have easily checked, and those page numbers were the e-way bills and my invoices. Then when the witness is shown this mistake, why haven't you disclosed this? So he says, inadvertently, we have not disclosed our copy. Now, our copy would not have this endorsement, reject materials, return to party. So the original was with them. So there's this confusion that sought to be caused. I did not disclose my copy. And the witness accepts that. I also accept that. Then the suggestion is given to my witness, 285, my lord will see. 280, no, 250, I'm sorry, 250. 250. The suggestion is given that you have not disclosed. Why you have not disclosed? Mr. Beriwal, the plaintiff has chosen not to disclose the bill cum challans in respect of invoices summarized in page 77, the inference of which is that the plaintiff has not given any proof of delivery of goods in respect of such invoices as stated in page 77 chart. What do you say to that? So his suggestion is goods were never delivered. This is contrary. This suggestion should not have been given to the witness because this is not the defendant's case. In the written statement, the case is paragraph.
Mr. Ghosh, see, all the things that is on record, the question and answer, what is correct? The document which is marked as Exhibit 1, correct? Exhibit 1 with objection. Let it be with objection. It can be with objection at the time of final argument.
I bow down, Malad. Normally, I would not have stood in the way. There is a now the Supreme Court has given a practice direction that these objections should be decided at the root. That is a different issue. It's of course the judge's discretion. Every court has the discretion. I'm just trying to make one clear that as far as the answers given to this document could not have been disclosed by them. That is my point. So the first point is that they have to overcome Order 11 obstacle. If they have not disclosed this document, they cannot rely on this document for any purposes. The second is,
by which question the document was produced?
Yes, 285. Manoj, just if I may finish with this chapter once, Manoj. There's different, the A copy of the consignment has not been disclosed. So if that was not disclosed, then if my learned friend gets a copy of that document, he can confront my witness. You have said you had a consignment copy. Is this the copy of that? Then he could have said something. They don't do this. They produce document C. B is with the transporter. They document C. Now this document has nothing to do with my witness's document, because this reject material would not have been there on my document. And that rubber stamp that is there, that's an original stamp. So this document is emanating from the defendant, the new document. Now, if that document emanates from the defendant, it was in its custody at the time of filing of the written statement, it could have disclosed this document. And if it didn't do so, the only exception in a commercial case, Lordship, a lot of us said in cross-examination, I can show any document. Only exception in a commercial case. Where's my book? The only exception is 7, Order 11, Rule 1, Sub-Rule 7, C3, refreshing. And that is the only thing my learned friend has relied on. Okay? Order 11? Yeah, 7C. No, 1, 7. Yeah. So, that is saying Rule 1, Sub-Rule 7, C3. Handed over to the witness.
Order 11?
Rule 1.
Rule 1.
Sub-Rule 7. C. Your Lordship has the amended,
yes, 7C.
7C, and it comes under 3. This was the
handed over to the witness merely to refresh his
yes.
memory.
Now, to refresh a witness's memory, my lord, my understanding of it is usually you refresh your own witness's memory. If it's the other side, you don't help him and refresh his memory. You confront him with a previously inconsistent statement under section 145. I've shown that section to your lordship. It says he can be only confronted with his previous previous statement in writing made by him. So 45 is not coming under. Now your lordship, I'll show it 159. What is refreshing memory?
Yes.
A witness may.
Evidence Act.
Yeah, Evidence Act. I'm reading it, my lord, while you're listening. A witness may, while under examination, refresh his memory. Now, the 159. My lord, there is a difference between a witness in examination and a witness in cross-examination. Your lordship will find 7.
Just a minute,
yes.
Mr. Ghosh.
Yes.
Just a minute.
Yes.
Usko bola. You are not understanding my language, or you don't want to work. Tell this court. Understanding language of the court, or you don't want to work. Why this lying here? Yesterday's argument note. I have given you keep in the file. Bring that case record to me. As the argument has been made yesterday. Unless you don't want to work, come to my channel and I will see where your
So, 159. A witness may, while under examination, well, not cross-examination, under examination. It's the witness's choice. If he wants to refresh his memory, he can ask the leave of the court and said, I want to look at my diary. Was it that date or was it not that date? Now, Your Lordship will see. While a witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of the transaction. So I've made a note in my diary concerning which he is questioned, or soon thereafterwards. I made the note that weekend, I remember, when I wrote my journal. So soon thereafter, that the court considers it likely that the transaction at that time was fresh in his memory. So a contemporaneous writing you can refer to. Now, Your Lordship pointed out the next line to me when I showed it. The witness may also refer to any such writing made by any other person. Such writing is to remind him of the transaction and read by the witness within the time aforesaid. Within the time is that contemporaneous time. So if my junior made a note and I remember that it was written in his diary, then I can ask the court, can I see my junior's diary? Now, using this to interpolate a document which has not been given, which is not permitted under Order 11. Now, this and in a commercial suit, I've also showed my lord the provision, Order 11, Rule 7. Not 1-7, but Rules 7 though. I had underlined it. No, yes, rules for avoidance of any doubt. Your Lordship has that. Rule 7. The last rule in Order 11, not 1-7, Rule 7. Certain provisions of CPC not to apply to a commercial suit. For avoidance of doubt, it is clarified that Order 13, Rule 1, Order 7, Rule 14, Order 8, Rule 1A shall not apply to suits on applications before the commercial divisions of the High Court. These three provisions, my lord, yes, shall not apply. Now, these provisions provide that the same language as 7(1)(c) actually provide that during cross-examination documents may be produced. But it's a general. The Lordship sees, for example, Order 13, Rule 1. 1 capital A. Need. Yes. Where does it come? Rule 1. Yes. So nothing in this rule shall apply to documents handed over witness. So this is there in 7, but it says produced for cross-examination of the witness of the other party. So if I want to challenge the veracity of that witness, I can show him a document. You've said that you didn't sign this contract. Here, I'm showing you a document. It's confronting. And the other is refreshing. He's saying that I've forgotten. Will this remind you? Then you can show him that. Now, this document, yeah. So now, if it does not fall under refreshing of memory, well, this document cannot be given under Order 11, Rule 1, sub-rules 8, 9, and 10, my lord will see. The only exception is 7(c)(3). So this first Order 11, Rule 1(8), I'm reading, the list of documents filed with the written statement shall specify the documents in power, control, custody of the defendant, are originals or office copies, etc. So first he has to specify. He has not disclosed this document. It's obviously coming from him because it's his document with his stamp and the original stamp. It's not that it's been given back to me. Then, so that it doesn't come. Then 9. The written statement shall contain a declaration on oath made by the deponent that all documents in power, possession, control, or custody of the defendant, save and except under 7(c)(3), that's refreshing memory, pertain to the facts and circumstances of the proceedings initiated by the plaintiff have been disclosed and the copies are annexed with the written statement, and the defendant does not have in its power, possession, control any other documents. So after not disclosing these documents in the written statement, he cannot. Now, when can he do so? It's 10. Save and except Rule 7C3, that's for refreshing. The defendant shall not be allowed to rely on documents which were in the defendant's possession, power, possession, control, or custody, and not disclosed along with the written statement, save and except by leave of court, and such leave shall be granted only upon the defendant establishing reasonable cause for non-disclosure along with the written statement. So in the written statement, it must be said that I cannot disclose this document because my neighbor has taken it away. Nothing. No explanation that unless they have despite their diligent efforts, they could not produce this new document. So this document which is being shown does not fall under this category. So first point, they cannot even disclose this document. Second point, yes. So they're circumventing that, I'm saying. No, it was objected. Well, that is exactly what was objected. He's recorded it after question. Yes. No. Now your lordship sees the document was shown in 285, not before that. So, my lord, it was this document, the copy of it was given to me after your lordship's order. We haven't been shown. Suddenly, in the middle of something, I'm showing you a document is given. Witness, and he's asked to read out. This question 285 is exactly the question I asked my lord. Please look at the document. Can you tell us the vehicle number and the weight? He says the weight is this. Even your lordship, that means your lordship and I can also prove this document. If this question is asked to me, I'll answer the same thing. We objected to it. It's recorded after 294. That's the commissioner's. If it was in court, I would have got up there and the objection is taken. Now the next question is, what is the truck number? That is also given. That also my lord read. I also read. Then it compares those numbers with the documents I have disclosed. Of course, they are matching. I'm accepting this would be their consignee copy. But that endorsement would not be with me, the rejected endorsement. So if document A and document C, if something is scribbled, it might be a photocopy of document A. But if some new thing is scribbled, then that endorsement makes it a different document. Like they might be the photocopy, might have been the format, might be the same. But that interpolation that has been done, and it belies their case. It will help me in this case also, because if they've rejected it, why do they have the original rejection with them? Why isn't it with me? They have said several times we are giving an original document. It bears the original stamp. It's a cyclostyle copy. Now I'm seeing the question what was put. Your lordship will see they have referred to it as an original. I'm seeing it for the first time today. Original. Question 285. I am showing you an original bill cum challan road. I've been arguing on this. Today I saw it's a cyclostyle, but the stamp is original. Now, if it's a cycle, so the question is also misleading. I'm showing you an original document. And the suggestion before this was, you have not disclosed those documents, so we infer you have not delivered the goods. A volte-face, 3 questions later, they say we have received the goods, but we have rejected. So one of these questions, your lordship, and especially 295, he disagrees. He says there is no proof that this document was sent to me. So and the last submission that I'll make, my lord, is that even if in a situation, if it was a previously inconsistent statement, if it was that he wanted to refresh his memory from that document, even in such case, my lord, this document could not have been an exhibit on which they can rely on for their defense, because in the written statement, this document is not referred to. In the written statement, they say we have rejected the goods. They don't say that I have rejected it. I send the consignee copy under rules, Order 11, Rule 1(9). That is there. So they don't plead that, which they had to plead that I can't produce it today. Yes. Now, these two documents are not the same. (78) to 119 is there. Those documents are there. It's the submission was made. We have surreptitiously not disclosed that document. And formally, we have exhibited the bill cum chalans. We have not. We have only exhibited paragraph 22. No, admitted that it's not disclosed. Yes, that's this. But my learned friend showed paragraph 22 of my AOE, of my affidavit evidence, which says bill cum chalans, etc. We have annexed here too and marked from page 78 to 119. Now, those documents 78 to 119, when I filed the plaint, they were with the defendant. If I have not disclosed the document I've referred to, the defendant under Order 11 has a right to call upon me to produce those documents. I have not produced. But I have not tendered my bill cum chalans. And that is the witness has said so. The documents I have tendered is page 78 to 119, whatever I call them. I can call them anything. I can call them any document whatsoever, but those documents are before my lord. Your lordship sees those documents. No. It's not been filed, but it's not been, that's what has been referred to is 78 to 119. Those documents are on record. Those documents, 78 to 119, are on record. They are not the bill cum chalans. They are not the consign. No, this is the confusion that's being caused. I saw that also last time. The bill cum chalans, copy A, has not been disclosed. The judge, the witness himself has also said, no, we have not disclosed. Inadvertently, we haven't. Now, 78 to 118. Now, your lordship will see those are not bill cum chalans. Those are my invoices and the e-way bills. Those are also exhibits. So there's no gap between 78 and 119. 5 pages are not missing. It's not someone has surreptitiously, we have disclosed. You want to see something? No. Yes, the lordship will see from 78 to 119. Here, my lord will see. Oh. These are the tax invoices. I've raised a bill. I've sold them goods. So 78 is a tax invoice. 79 is a e-way bill, the corresponding e-way bill. Now, there will be a corresponding consignee note with this. That has not been disclosed. It's been disclosed for the other set. That has not been disclosed. Now, they are showing their consignee bill, their copy of it. They are trying to show that now and saying, look here, I've rejected the goods. And their suggestion that I have not disclosed this, though inadvertently or by mistake, we have said bill cum chalans, e-way bills, etc. But those bill cum chalans from 78 to 119, your lordship will see there are only e-way bills and invoices. So this is the exhibit. Yes. In the affidavit, in evidence, paragraph 22. There the mistake was made. But I'm saying the documents themselves have been exhibited. Paragraph 22. Page 9. Now, really, the only saving grace for us is we mentioned the page numbers. And those documents are on record. They can see which are the documents. The copies of the said bill cum chalans have been disclosed in the judge's brief at 78 to 119. Paragraph 22 of the affidavit evidence. My learned friend placed it on the last. But this judge's brief is just the documents. My lord will just see this. It's just this is a side issue. This is document A. We are really talking about document C, whether they can disclose. Your lordship sees the last line, copies of the bill cum chalans are disclosed at, luckily the page numbers have been given. So the defendant was not misled. He could see the page numbers. They were the invoices and the e-way bills, but not the copy of my consignment. Now that consignment slip would show I have given it to the transporter. And my consignment bill at the time when I'm loading the truck, when I get it, that won't show that these goods have been rejected. The goods have to first be delivered, and that is the case in the written statement, that the goods were delivered to them, they tested it, and they sent it back. Show me the written statement. My lord will see the written statement. I'm just reading it out, paragraph 7. The plaintiff has wrongfully and fraudulently shown sales in respect of goods which were never received and or delivery refused by the defendant due to poor quality. So the delivery of the goods is not disputed. They're saying that we rejected it. If they didn't get the goods, they wouldn't know if it's poor quality or not. This is paragraph 7 of the thing. The defendant's testing factory, then 5 trucks. Then here they don't mention that I endorsed the consignee bill and sent it back. Not mentioned. But their case is that it was delivered and it was refused due to poor quality. No, we objected. It's not. No, my lord. My lord, from 285 he shows it. It is only after 294 that the commissioner records it. We've been objecting every. No, your lordship sees 285. Yes, yes, my lord. I'm showing you. Right. Yes. This is. Yeah, but what objection as far as this question? No, your lordship sees the question. This is the question I asked my lord first. What is the weight? He says the weight. No objection. When he comes to the proving the document, whose handwriting is this document in? Your lordship will see rejected materials. Whose handwriting is that in? Is it asked? That document is different. It's once that document has been tampered with or rewritten on top of it, it can't. Then they ask him, what is the truck number? He says, yes. Is the truck number this? He says, yes. Why won't he? Is that an admission of the document? It's admission that is written on the document. Then, my lord, then they go to other documents and say the truck numbers and the things match. He says, yes, they match. Now it says 292. Please look at the entirety. At the document, you will find an endorsement on the remark column which says rejected materials. Yes, it is so written. It's a fact. This honestly answered. Will you find from this document on receipt of the tax challan, the tax invoice was raised. There was an endorsement on the bill cum challan which says to be billed. There is no relation of the words to be billed with the tax invoice. So that one was there. It's also on my ones, it was there. I'm handing over a bunch. Now that is one document shown. A bunch is shown to them. We object immediately. All these original. Now they are saying it's not original. It appears to be a cyclostyle. Original bill of command being consignee copies with the endorsement material rejected. Please take a look at the document and tell us what do you have to say. Yes, it is consignee copy. The same is written. He says that. Then I object that the learned defendant confronts the witness. If I had contradicted, my witness had contradicted, he could have confronted. Now the specific stand is I'm confronting the witness. And the same is tendered and marked Exhibit 1. Then it's recorded subject to objection of learned counsel for the plaintiff that the defendants now disclosed were never disclosed in the written statement. Number 1. As such, no new documents can be disclosed. Again, Order 11, Rule 9 and 10. The witness on the earlier occasion was not called upon to produce such documents. These documents were never with me, so I could not have produced them. Nor was I called upon to produce the other ones, which were missing inadvertently from my affidavit. And as such, only done during today's cross. To this, the learned counsel of defendant submits that the tenure of cross-examination should be tenor, T-A-N-O-R, it should be, of cross-examination would establish witness has admitted not having disclosed the bill cum challans of the second invoices. True, I have not admitted. And in order to charge or refresh the memory of the witness, the other side's counsel is refreshing my memory. It's not confronting. First, they say use the word confront and the refresh. All these orders, order 13, order 7, order 8, it says you can produce it during cross-examination or it can be used for refreshing memory. They're two separate things. Refreshing is a more friendly gesture to refresh your memory. Confronting is you have lied, I'm showing you a previous statement. So now both, in order to charge and or refresh the memory, the counsel confronted the witness. The witness has not disputed such consignee copies and therefore the documents are tendered. Where has he admitted this? The next question that's put to him, he says, I do not agree. There is no proof that the things were rejected. All he has said is as a courteous witness, he's been asked, is it written here? This, he has said yes. Is that proof of a document, which is not even, he's not the author of the document. The original is not with him. It's not their case that the original is with me. They don't disclose this from their possession during the written. So lastly, 4 things. One is that, my lord, the confusion caused by Exhibit H, the document A and document C are 2 separate documents. So you cannot say, you did not disclose this, I am disclosing it, to show that you lied. That's number 1. That doesn't happen. The suggestion put was that you haven't disclosed because these goods were never delivered. That, my lord, is contrary to their pleadings. And a suggestion should not be put by counsel to a witness, which is not their case. They can only put their case. My lord, there are judgments. They should not go beyond the cross-examination, also should not be beyond the pleadings. I'm not going into that. That I will argue perhaps at the time of argument. So that was number 1. Number 2, order 11 is very clear for commercial cases, only for the purpose of refreshing memory. The only provision I found for refreshing memory is 159. It says a document written by him or which he remembers was written in front of him contemporaneously. This document does not come under refreshing memory, does not come under 145, does not come under order 11. And finally, the point I wanted to make was, yes, finally, even if this document is on record, and it can be marked for identification, it will only go to the credit and veracity of the witness. He cannot bank on this document later in the argument and say, I exhibited the document, I've rejected the goods. This document. So this document. No, but well, any other document by this route, I can show any document to a witness, surprise him, catch him by, and he might know of the document. It might be a genuine document, but if you haven't disclosed it, this way you can't circumvent order 11 bar.
On that document, several questions have been.
Yes.
When the 5 documents were there, then you
yes.
woke up and started objects.
But well, if I don't see a document, I don't even know if it was a disclosed document.
Finally, see the recording of the commission. Commission also not regretted that he admitted for the printing and asked for the document. Can you see that? He has not asked for the document. The document is produced. When see, then the document can be produced.
When refreshing a memory, if it was really a genuine, if it was. So in this way, because the other side. Well, we are objecting. This is the same within 9 questions. 9 questions. 85, 86, 85 and 86 are only questions on the document. The rest of them are questions on my documents. Yes. No, from 80, I'm coming, my lord. 85, 86 are on that document. They ask him what is the weight, what is the truck number. Then 87, it goes into my other document saying the truck number is the same. Then, my lord, we'll see. These are my documents. 89. He says compare it with your The truck number and the weight is same. Well, probably the consignee copy is they are copies of the same document, but that endorsement changes document C to document A. It's not the same document. Then he says, look at the entirety, 292. Look at the entirety of the document and you will find an endorsement. He'll say, you will find an endorsement. Yes. His question, my lord, a good witness, if you ask them, do you know what the time is? He is meant to say yes. He's not meant to say the time. So he says that this thing, is it, do you know what this, is it written here? Yes, it's written here. But this does not go to an admission of the document. And even though if they had disclosed it, I would have probably not objected to it if this remark wasn't there. Rejected goods. This document is a brand new document. And if you don't come over the hurdle of Order 11, well, this cannot be shown. And even if it is done under 145, which it cannot be done, but even if your lordship says to confront or refresh the memory, this document can only be relied on for the purpose of veracity and not their defense. So this is contrary to their defense. And we have but I have prepared a 2-page note if my lord keeps. No, the judgment I can show. The judgment that there's a practice direction now, Supreme Court has said that if an objection is taken, it should be heard. And your lordship has heard it. So your lordship will decide it, because to leave it open again after 5 years when the suit comes up for hearing, which paragraph? My lord will see this 2021 10 SCC. No, online. 2021 10 SCC 598. Now, if my lord comes to page 604, paragraph 15. I'll read it. Paragraph 15 and 16. Apart from section 148, 148 of the Evidence Act says that he will be compelled to answer relevant questions. There are other provisions in the Evidence Act which define the ground rules for cross-examination. During questioning, no doubt, the counsel for the party seeking cross-examination has considerable leeway. Cross-examination is not confined to matters in issue, but extends to all relevant facts. However, if the court is not empowered to rule during the proceeding whether a line of questioning is relevant, the danger lies in irrelevant, vague, and speculative answers entering into the record. When he's asked, this is the car number, he says yes. Further, based on the answers to what subsequently turns out to be irrelevant, vague, and other impermissible questions, more questions might be asked and answered. If this process were to be repeated in a case most witnesses, the record would be cluttered with a jumble of irrelevant details, which at best can be distracting and at worst prejudicial to the accused. Therefore, this court is of the opinion that the view in Bipin Shantilal, this decision of 2001 says you should hear it at argument, should not be considered as binding. The presiding officer, therefore, should decide objections to questions during the course of the proceeding, or failing it at the end of the deposition of the witness concerned. This will result in decluttering the record and, what is more, have a salutary effect of preventing frivolous objections. In given cases, if the court is of the opinion that repeated objections have been taken, the remedy, of course, depending on the nature of obstruction and the prolixity of the line of questions, may be resorted to. Accordingly, the practice mandated in Bipin Shantilal stands modified in the above terms. Your Lordship must hear this, because this document is being smuggled in. If they made an application, I'll show another decision. Another decision of a coordinate bench. I'm not showing the decision that it should be not beyond the pleadings. The pleadings is I've rejected the goods after testing it. And the suggestion given is you never delivered the goods. That's why you've suppressed these documents in H. That is different. Now, this is a coordinate bench decision, my lord. I'll just give it to you. Justice Mojumdar, September 11. Here, the defendant made an application during cross-examination that I want to rely on certain documents. Ultimately, the application was allowed. But Your Lordship will see on what grounds. Where's the thing? Now Your Lordship will see which is that part. Well, page 10 on top, it's the page numbers there. Page 10, the second paragraph. Admittedly, my Lord has that. Admittedly, the documents purported to be produced had not been disclosed. These documents were produced for the first time during cross-examination. Then Order 11, Rule 17C1 permits production of documents for limited purpose of examination, cross-examination. But my learned friends cannot rely on one, they can only rely on 7C3 because of the two subsequent provisions in the commercial code. So only 3 applies. Here, 1 was there. As explained in Wahid's case, admittedly, documents sought to be produced were not disclosed by defendants. The defendants now cannot take a roundabout route invoking the provisions of Order 11 Rule 17 and Order 11 Rule 5 to adduce evidence in evidence those documents. An attempt to circumvent the rules applicable for production and disclosure of documents should not be allowed invoking Order 11 Rule 5. However, Order 11 Rule 17C permits production of documents in contingencies stated therein. One is for the purpose of cross-examination. Limited purpose of cross-examination implies the purpose to challenge the veracity of the witness or to impeach his creditworthiness. Nothing more, nothing less. The documents cannot be used to set up a defense or prove any claim taken in the written statement. So this document at best could have been shown to show that my witness is not truthful. I'm confronting him with a document. That's the purpose of cross-examination. Then in the Bombay decision, observe that with reference to Order 8 Rule 1A, pari materia, and relevant to consider here that if the defendant was using any document not already disclosed, even if it was in his possession or power, only to confront the plaintiff's witness during cross-examination, it will not be obligatory for the defendant to furnish advance copy of such document. It was further observed that such provision has been made to ensure the potency or effectiveness of cross-examination of confronting the witness is not whittled. In other words, if a document was furnished in advance, the possibility of the witness modulating his version. If that happens, efficacy of cross-examination is bound to be affected. As contended before this court, the defendants are wanting the subject documents to be produced for the limited purpose of cross-examination to confront the plaintiff's witness. The petitioners, therefore, are justified in contending that they were not obliged to furnish advance copies. Then, the judgment is quoted. Then, the next paragraph, page 12, there is no cavil in the proposition of law that evidence cannot be adduced beyond the scope of pleading. There are authorities to state that on substance of pleading is to be looked in. Then, the Supreme Court is cited. It is well settled that in the absence of pleading, evidence, if any, produced by the parties cannot be considered. It is equally settled that no party should be permitted to travel beyond its pleadings and that all necessary and material facts should be pleaded by the party in support of the case set up by it. The object and purpose of pleading is to enable the adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should settle the essential material facts so that the other party may not be taken by surprise. Pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to defeat the justice on hair-splitting technicalities. However, this proposition does not stand in the way of production of documents under 171C1, and they were introduced. So here, the documents were permitted, only last 4 lines, only for the limited purpose of cross-examinations to impeach the creditworthiness and challenge the veracity. The documents must not be used to set up a defense case or support pleadings in the written statement. If produced, the documents would be marked and considered for that limited purpose. So even if it was done, if they overcome this hurdle and confronting a witness, 145 says only his previous statement. So it doesn't really come under confronting. They are They are narrowed down in the commercial suit to 7C3, handed over to a witness merely to refresh his memory. Now, is this document being given to merely refresh his memory when it's been written by some third party? The writing hasn't been proved. Nothing has been proved in that document. Who has issued it has not been asked. Only thing has been asked is what is written in this document. No, but if he's not asked, the relevant questions are not asked and the document is proved. What is the relevant question? Who has issued this document? Have you seen the original of this document? Have these questions been asked? It's asked, please read it out. Read out this endorsement. And 295, he says, I do not agree. There is no proof that the goods were returned. There's no communication given to me. He says that. If I show the witness his mark sheet from school, you have not passed school, he'll admit the document if he knows that that's his mark sheet. That doesn't mean that if it was in your possession, you didn't produce it. People make applications and fail. They have to show some diligence why they have not disclosed this document. And the only reason is, but that's for final argument, is that it's been interpolated and manufactured. Well, this way, they have their methods. You can make an application. You can show that. It's a bit too late, I think. But since the words were used that it was surreptitiously, we have not disclosed these documents. Then it's this sort of questioning. They're very unfair. I've just used the word. It is unfair that this document is to be allowed to be used at this stage. And all of before your lordship passes, also your lordship may pass a direction, which my learned friend had offered on the last occasion, that she can complete her cross-examination without referring to this document till your lordship decides. That was the
Thursday.
Yes. That your lordship.
Only objection I raised while order was being passed, that your lordship was recording, it was nobody's document. I objected to that and I referred to his affidavit of evidence. My lord, your lordship will appreciate today that an affidavit of evidence is not a pleading, it is his deposition. And he has, if he had come to the box and made this statement on oath, consequences of giving wrong evidence, your lordship knows. And lordship, if your lordship want to, they have referred to judgments and made a lot of submissions, my lord. I would like to come back with a note to answer what he has given. Even though, my lord, I am ready and willing to not to put any further question with regard to this document.
That can go on, but this...
Because I don't want to go into the merit now. Because my cross-examination is pending. Lord, in that event, your lordship will allow my junior to make his submissions because I was not present when my learned friend started. And we would like to put in a note also, my lord, as my learned friend is.
I handed over a note. But those the two cases that I cited is not in my note because I was not planning to cite them. But since my learned friend cited a case, note
তুমি নোট ওদের যদি নোট না দেয় আমরাও দেবো না তো ও তো দিয়ে
আমি তো দিয়ে দিয়েছি
withdraw করবে ওটা তাহলে আমরা
well if your lordship doesn't require that was
then
the
we
note
will
I made
also
for
not
my
if
submission.
Mr. Ghosh does not rely on the note and it
It's
is
whatever
written,
I've said today. What I've said is there, so I'll take it back. The note if
Because
it's going to
lordship has-
cause delay, because my note doesn't have my 3 cases that I cited. 2 cases. 87.
my lord, Mr. Ghosh has relied on section 159. My lord, my lord, kindly takes the Evidence Act once.
No, it's a note. No. Down.
Section 159 is what he was relying upon. My lord, the expression refreshing memory is there. My lord, the object of Mr. Ghosh was to, my lord, persuade your lordship that since the only exception carved out in Order 11 Rule 1, Sub-Rule 7, C3 is, my lord, refreshing, which is saved under Order 1, Order 11, Rule 110. Therefore, that is the procedure under which document can come in. Otherwise, no document can come in. That's his submission. And he says, my lord, that in cross-examination, you cannot refresh a memory. It's always your witness, you refresh your memory. This is not correct, my lord. Kindly seize the language, my lord, of 159. A witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of the transaction concerning which he is questioned, or so soon afterwards that the court considers it likely that the transaction was at that time fresh in his memory. Now, two expressions, my lord, I rely upon. A witness, my lord, it does not say witness facing examination in chief, my witness or your witness. That is one. Second is while under examination. Kindly marks the, my lord, expression examination. Now, my lord, kindly comes to, my lord, section 138 of the Evidence Act. (138), my lord. The examination in chief. The examination of a witness by the party who calls him shall be called examination in chief. Cross-exam 137, I'm sorry, my lord, 137. Yes, my lord, the expression used is, in examination in chief, is examination of a witness by the party who calls him. Cross-examination, kindly sees, again, examination of a witness by the adverse party. So, my lord, there is no distinction in the manner of examination. The expression used in 159 is also examination. So, whether it is plaintiff's witness or defendant's witness, my lord, it's examination, and I can definitely, my lord, refresh his memory by, my lord, confronting a document. Now, all this hue and cry about, my lord, the nature of the document. Mr. Ghosh says that this is a document. There are three sets of documents A, B, C. This is how he describes. One is, my lord, a consignor's copy, one is a transporter's copy, and one is a consignee copy. Therefore, he says A, B, C. When he, my lord, there are two sets of, my lord, transactions in the given, my lord, facts. When he, my lord, discloses this bill challan in the first set of circumstances, he discloses the consignee copy. That is document C. Kindly, my lord, takes note of paragraph 9. No, my lord has not. My lord has not gone through it. My lord kindly comes to paragraph 9 of the affidavit of evidence. He has relied on para 22 because we on the first day relied on that. Now kindly comes to para 9. It's surprising that today this stand is being taken. No, examination, my lord, affidavit of evidence, my lord, paragraph 9, page 4 of the affidavit. Lordship has the possibly the affidavit separately. Paragraph 9 starts with the said transporter, my lord. The said transporter duly issued a bill cum road challan for each consignment acknowledging receipt of the said goods. Copies of the said bill cum road challan were given to the plaintiff and the original was carried with the transporter. I have seen the original bill cum challans along with the e-way bills and can say that the true copies thereof were maintained in the records of the plaintiff. Then, my lord, he tenders from pages 11 to 73. This is for the first set of transactions. Kindly for a moment takes page 55 of the first volume judge's brief. Page 55. Side by side keeps paragraph 9 and takes page 55. My lord, at the top right hand corner, my lord, kindly open. Yes, my lord, at the top right hand corner, lordship marks the expression consignee copy. So the witness relies on this, my lord, original bill cum challan, my lord, for the first set of transactions. And the, my lord, averment or the evidence, just because it is, my lord, order 18 rule 4 does not mean that this is not evidence, this is an averment. This is also the witness's evidence. Now, my lord, compares paragraph 9 with paragraph 22, how he describes the second set of transactions. Again, he says, my lord, that the transporter duly issued a bill cum road challan for each consignment acknowledging receipt of the said goods. So for the first set of transactions, the same evidence is my lord, consignee copy. For the second set of transactions, Mr. Ghosh is trying to give an impression to the court. It should have been documented the consignor copy and not the consignee copy. Hence, it is not refreshing the memory. This is, my lord, fallacious. And 11 to 73 are two sets of documents for two, my lord, parallel, my lord. Yes. Now, for the first set of transactions, the witnesses' evidence is that this is the, they have disclosed. Not disclosed. So, I confront with, to refresh his memory here. Yes. Yes. Correct. Yes. Yes.
Wait.
My lord, the moment at the time of refreshing the memory, the witness facing cross-examination admits the document. It has to be marked as an exhibit. Now, what is the value or evidentiary value of such document is a question to be determined by your lordship either now or, my lord, at a later stage. This is, that I will distinguish that judgment because it has modified 2001, but I will distinguish it. My lord, it's in a criminal trial pursuant to rules framed by High Court. Supreme Court felt that in all criminal trials, my lord, these trials are getting, my lord, at the time of final hearing, my lord, the learned presiding officer or the learned judge is not aware which document is an exhibit and which is not. What is the evidentiary value? Degree is, my lord, the degree of, my lord, the nature of the, my lord, examination in a criminal trial is far more severe than, my lord, the nature of examination in a Evidence Act does not make a distinction. It does not.
Civil can be cluttered.
So my lord, endeavor is to show that the witness is referring to the consignee copy as the transporter. So I have refreshed the memory of the witness. He never raised this objection, my lord. My lord, next is my lord, next Mr. Ghosh relies upon Order 11 Rule, my lord, 17C3. There is no dispute with this, my lord, because the statute is very clear. There is only one exception in terms of, my lord, rule, my lord, that sub rule 10, that if it is, my lord, for the purpose of refreshing, then 7C3 is, my lord, an exception which is carved out. According to me, my lord, since the witness was referring to consignee copies for the first set of transaction, we have, my lord, refreshed the memory by producing the consignee copy for the second set of transaction. And therefore, this is refreshing the memory, no objection raised. And, my lord, the witness has also identified the document. If he had not, my lord, possibly what is being argued today, lordship could have, my lord, held in favor of the plaintiff. But now it's too late in the day to, my lord, contend otherwise. This is, my lord, second. My lord, next, my lord, kindly takes Justice Mojumdar's the coordinate bench order, which has been cited. My lord, 4 distinguishing features of this judgment. My lord, this was, my lord, the Honorable Court was considering an application under Order 11, my lord, Rule 1, my lord, made for disclosure of documents. Lordship here is not faced with a similar situation. 2, my lord, the witness here admitted the document. In our case, in this case, my lord, that question never arose. 3rd is, my lord, no objection was raised in our case when the document was, my lord, shown for the first time. My lord, that is the juncture at which, my lord, somebody should raise an objection that you cannot show him this document because this is not disclosed with the pleadings and it is hit under the provisions of Order 11. And 4th is, my lord, kindly takes the last paragraph of this judgment at last page, my lord, the penultimate paragraph. Here also, my lord, the learned judge does not use the expression refresh. It is confronting. So for refreshing memory, I can still confront the witness with a document. So this is, my lord, the distinction I wanted to make to the argument made by Mr. Ghosh. Yes.
When it was seized, whether he signed the document. So for referencing that, it has to be placed before the witness. Then he will reference and he will say, yes, this is my document and this is my signature. Then it will go in.
Correct. Now, my lord, applying the same, my lord, logic here, my lord, this witness.
Reference means, because that's what the cross exam is character. Order 7 bulletin can we see? 110.
Yes, my lord.
Order 7 rule 1, order 1 bullet 7. Order 1, order 710. They will accept 7 defendants will not be allowed to decide upon the document. So that's why if this document was not on record and displayed before the witness, so he can refresh his memory and put the question. You had done, and witness has given the. Now only the question is whether that is to go as an exhibit or it will only it will kept on record.
Yes. Correct.
Yes, ma'am. Only one.
That is the only question which lordship will, if lordship has since heard us, my lord, will decide that here and now.
Only on the point of law, 138, the distinction is very
No,
clear.
I have not distinguished the last
No, no.
judgment. Let me just complete that and
I'm
then
just
Mr.
saying this is not for, this is for both of our education.
Very
The examination and cross-examination must relate to relevant facts, but cross-examination might be confined. There's a big distinction between examination of a witness and a cross-examination. I have never seen another side helping my witness to come to refresh his memory and give the right answer. No, no, it's not May, it's March.
My lord, Mr. Ghosh used an expression that refreshing the memory is a very lenient gesture to a witness. My lord, I disagree with that. My lord, to refresh, if the witness, my lord, is avoiding, my lord, answering on a particular document when the witness has, my lord, adduced evidence, positive evidence, that at the time of tendering documents, I have disclosed 3 sets of documents. One is the, my lord, invoice, one is the, my lord, bill cum challan, and one is e-way bill. My lord, at the time of tendering, we see that, my lord, there are 2 documents, bill cum challan is not there. My lord, I call upon him to produce that. My lord, my lord, does not produce that. Then I show the consignee copy to refresh his memory. My lord, this I am entitled to in law. Very well, man.
Grateful, man. I'm sorry we took so much of it.
My lord, the Supreme Court, the
claim
2021
Supreme
is
Court, 30 lakhs of this suit. Well, that's why I'm not invited to the cross-examination. But we are going beyond that now. 30 lakhs. 5 trucks of goods, whether they've got it or not got it. Now this is
my lord, the distinction for 2021 is, my lord, it's, my lord, for the purpose of a criminal trial and on the basis of your lord, if your lordship takes note of the first 4 paragraphs of the, my lord, judgment, my lord, courts were facing difficulty, my lord, and that is why, my lord, some of the high courts had, my lord, framed or flagged, my lord, practice rules, how it is to be done. Then there was a dichotomy. Then, my lord, the Supreme Court intervened and said that this is the procedure to be followed in cases of criminal trial, and to that extent modified the view in, my lord, which was rendered in 2001, that Supreme Court decision which we cited. So, my lord, I say that evidentiary value, witness identifying the document in cross-examination. Very well, I'll take it, my lord, later. Lordship may reserve it since we are not filing notes, my lord.
Notes file করছো না তো তোমার
No, ধ্রুবদাও নিয়ে নিয়েছে। Note দিয়েছে ধ্রুব?
But I want to take back my note, but it's lost in your lordship's brief. I've given you the note anyway. দেখে তো বলছি এটাকে দেখা ওকে তাহলে আপনি ফেরত দিয়ে দিন না
না এই নোটটা আমি না
না না
এই ধ্রুবদার নোটটা দিয়ে দে এটা জাজমেন্টটা খুলে পুরো দিয়েছে আমাকে
না বলছি যে
তোমার নোট ফেরত চাই
না ওকে দেখাতে চাই এই যে এই কাগজটা এই কাগজ
Grateful, my lord.
But only one thing I would like to. Lordship, one small issue is still pending, that the cross-examination was stalled for it.
Grateful.
না, আমি তো শুরুতে ছিলাম না।
Number 9.
My lord, in this matter, I'm appearing for the plaintiff, my lord, petitioner. My lord, this matter has come at my instance because, my lord, the parties are agreeable, my lord, to settle the matter, my lord. My lord, may I place before my lord? Just kindly.
Lordship, I'm appearing on behalf of the defendant. The matter is already settled and defendant has already paid the settled amount.
If my lord kindly takes the terms of settlement, my lord, we have, my lord, the total claim was around 44 lakhs. There are two, my lord, it's a principal amount. My lord, the principal amount was 22 lakhs 59,000 and there was an interest component which is 21 lakhs 40,000. My lord, yes, my lord, in paragraph 4A, my lord, if my lord kindly sees. My lord, the page 2, my lord, of the terms of settlement which has been entered into, my lord. My lord, my lord, 23 lakhs around, yes, my lord, there has been paid, transferred, my lord. Yes, my lord, on 3rd of March 25, my lord, by way of an RTGS, my lord. My lord, in this matter, my lord, if my lord recalls also, in month of January 21, my lord, learned receiver was appointed, my lord, pursuant to my lord's direction, and there were directions, my lord, that to seal 3 shops of the defendant, my lord. And learned receiver, Mr. Kejriwal, is there, my lord.
Lordship recalls, and I'm in possession of the 2. But the report I not submitted because on the last occasion the 3rd property was not sealed. Lordship said directed me to take possession of that and then file the report. My lord, the report is ready, but my lord, as your lordship.
Yes.
But may I file it during? And then, my lord, is
it Monday then?
My lord, today I'll file it in the course of 1 hour.
Lordship, I'm sorry to interrupt, but your lordship's mic is off.
আমি করবো আজকে রিলিজ হয়ে যাবে ওর প্রপার্টিটা
আর বলো তো আস্তে আস্তে করে দিই যে বলে আমার ফিস গুলো আমার কাছে আছে সেই জন্য মাই লর্ড ওর উইকেন্ডে যদি জিনিসটা আমি বলবো
মানে ওয়ান সাবমিশন
With my lord's kind indulgence, one aspect what my learned friend was discussing, my lord, the thing is that the 2 shops has been sealed. My learned friend is desiring that if the report can be filed at 2 p.m. today, so the keys can be handed over today, and my lord,
Lordship kindly indulges, my lord, the defendant can open his shop and. That's why unless the court will not go through the report, how the court can say open the
Right.
Right, Lord.
My lord, 320, my lord.
Grateful.
Deeply obliged, my lord.
One part.
Number 10.
My lord, this is my application, my lord. My lord. But in this matter, my lord, this is my application, my lord. My lord, in this matter, my lord, lordship kindly remember, my lord, that the matter was filed in May 2024 and the scrutiny was not complete. Finally, it was drawn to the my lord's attention at the intervention of my lord. My lord directed immediately within 1 week everything should be completed. No, my lord, no, that is over, my lord. Thereafter, so the consequential delay, my lord, in the issuing of the written summons, my lord, that is the kind. Yes, my lord, immediately it was drawn. Darao bhai. Department's notice, my lord's notice, it was immediately drawn, and thereafter the needful was done. No, in the meantime, they wanted us to wait, and my lord, 3 times, my lord, we had mentioned. Thereafter, my lord, it is not on the first day, my lord wanted us. 19th of my lord, February 2025, after this order, my lord, the defect was cured. Now, my lord, there is a consequential delay in the, my lord, issuance of the writ of summons. My lord, but this is my application, my lord, for the extension of the time, my lord. The date of issuance of the writ of summons may be suitably extended, my lord. My lord, it is before the master. Master has, my lord, referred it here, my lord. So, my lord, there is no master summon, my lord. Only the consequential delay that was occurred. Where is, my lord? I had no fault, my lord. Now, my lord, there is a consequential extension of the writ of summon, my lord, time for lodgement of. May I pray for. My lord, yes, my lord. My lord, paragraph, my lord, kindly come to paragraph 3. After my lord's order. My lord, that I have just mentioned, my lord. Yes, my lord. Oh, yes. 21st of February, the application was filed. Then it has come in due course, my lord. What is it? Yes, it on the side. May 2024, my lord.
8th July 2024 was agreed.
July 8, 2024. তোরা কিছু জেনে বলিস না তুই নামটা লেখুন এই তবে স্কুল চলে না Yes, madam. Una, ya es. Or in terms of BCD. And my lord, may I submit one thing, my lord? Since the defendant is throughout appearing, even before the lodgement of the. So, my lord, may that be the yes, my lord.
My lord,
What is the
let it be
use of
served upon the party itself, my lord, defendant. I have
idle
instructions to
formality?
appear. I have instructions to appear. There is no because
May that be
we were
recorded?
served with the notice. That's why.
Because that was the observation of my lord in
My lord, that let it be served upon the party itself.
as
my
your
lord.
lordship, please. But in coronation, ministerial versus coronation matter, my lord's view was same. That is recorded, my lord. Anyways, my lord, grateful, my lord.
This is my suit. I appear on behalf of the plaintiff. On the last occasion, Lordship had directed affidavits. My lords, I have written instructions, my lord, to with. My lord, I had an Order 39 Rule 1 application, but my lords, I have. Lords, they were. I had met them today. I don't know if they're here. But my lord, I have written instructions to withdraw this matter, my lord, because an Lordship recalls. Yes, my lord. Yes, my lord.
My lord, I'm for the defendant. Lord, if they are withdrawing, my lord, then we do not have
Lordship
any
recalls, my lord. Lordship, they had filed a prior suit before we had filed this suit on 24th January 2025. They had already filed a suit in October or November in Gurugram before the commercial court. No, my lords, here we will be contesting the suit there, my lord. So withdraw this, my lord.
My lord, may I just submit one thing? My lord, to their injunction application, we have already filed an opposition.
But only yesterday we've been served with the affidavit in opposition.
Lord. Lord.
Very well, my lord. But though, my lord, the affidavits had been directed, my lord, though I am withdrawing, but no, the issues, they remain open because we'll be fighting it very well. Grateful, my lord.
One pass for matter if the lordship take.
Lordship, I am for the Your Lordship, the applicant in the contempt application. Should on the last occasion, Your Lordship directed the contempt number 1 and 2 be present in court, and Your Lordship, the rule in connection with the contempt number 3 has also been served.
Lordship, I am appearing, my lord, both the contender is present, my lord. My lord, I am tendering unconditional apology with regard to the non-appearance before lordship, my lord, despite serving. My lord, so far contempt application part is concerned, if your lordship subject to kind sanction, my lord, only my lord 2 weeks time, so that we may file a short affidavit on the basis of that your lordship can. No, my lord, no. After getting the information, my lord.
Lordship's voice is not coming, Your Lordship, due to the mic, Your Lordship. That's
Still they are using the mark.
Yes,
after-
Your Lordship, that's Your Lordship. We have annexed, Your Lordship, page 140 of Your Lordship, the contempt application. We have disclosed the receipts.
And 141 also.
No, now they are telling that they are not using. What is the date of this? This is the date of January 2020. Yes, 25 you use that. January.
My lord, so far the document is concerned, my lord, I am being officer of the court, assure, my lord, after getting information, my lord, we have not proceeded with the matter. Only I coming before lordship and taking instruction from my client what the actual happened. Because when the suit is pending, since, my lord, we are not proceed with the matter. But even when contempt was come on before lordship, only clarify whether it has been issued any dealer or anybody's, my lord, just as instruction and file a short affidavit before lordship in connection with the matter for your lordship.
So once the notice was issued, why your clients are not appeared before this court?
My lord, there is some miscommunications, my lord. I won't like to blame anybody being officer of the court, my lord. This is a mistake on our part, my lord. Just your lordship, kindly.
Lordship, let them file an affidavit. Only one thing, if Your Lordship kindly considers.
Well, 1 and 2, my lord.
What about 1 and 2? What about the 3?
My lord,
She is the distributor.
Again, the 3 has received the summon notice.
Yes. 3 has already been served on subsequent service.
Who is the 3?
She is the distributor, Your Lordship, of the main company, Your Lordship, who is the defendant.
What is the name? 3? What is the name of the defendant?
Kripa Shankar Kushawa,
Huh?
carrying on business under the name Calcutta Pipe Fitting Store.
What name?
Kripa Shankar Kushawa.
Where it is?
At page 8 of the contempt application.
Kripa Shankar Kushwaha. Calcutta Pipes Fittings.
Calcutta Pipe Fitting Store.
Proprietor. Jayaprakash Nagar, Bihar.
Bihar, Your Lordship.
So appearing for the petitioner, so appearing for the alleged contender number 1 and 2. Yes, what you want? What your submission?
Only one submission. Let them file an affidavit, Your Lordship, and kindly, Your Lordship, direct them to issue notices to their distributors so that no further sale can be done. What I apprehend, Your Lordship, that they have sold out those particular goods and now the distributors are selling.
my lord, so far the submission which my learned friend, my lord, has arisen before lordship, my lord. My lord, the battle between the two brother, elder and younger brother, the amicably settlement of the business is there. So the using of trademark or the application which is meant before the appropriate authority, rightly, wrongly, this is a separate issue. But when the matter was contempt, my lord, I assure you, lordship, my lord, we are not proceed with the matter at the present. Only your lordship can you consider.
For the counsel for the alleged content number 1 and 2. Plaintiff has filed affidavit of service showing the service of notice of the present contempt application of the alleged content number 3, but none appears on behalf of the alleged content number 3. Accordingly, the content number 3 is directed to appear before this court in person on the next date fixed, failing which appropriate order will be passed. Full stop. Counsel for the alleged content number 1 and 2 submit that his clients have, the defendant of 1 and 2 have received the notice of the contempt, and he undertake before this court that the defendant number 1 and 2 will not violate the order by using the mark of the plaintiff.
Correct.
And he will file affidavit in opposition in connection with the contempt application. Let affidavit in opposition be filed within 2 weeks.
Lord, at least big matter, my lord. 4 weeks I am seeking, lordship.
Within 3 weeks.
3 weeks.
Reply if any there to be filed within 2 weeks thereafter. Full stop. The defendant's number as per the undertaking given by the learned advocate appearing for the defendant number 1 and 2, they are further restrained from using the mark of the plaintiff till the disposal of the instant application. Full stop. Let the matter appear on 5 weeks, 2 weeks, 2 weeks, 4 weeks. 5 weeks. Let the matter appear on 11th April 2020.
I'm grateful, Your Lordship.
Defendant number 3 is directed to appear before this court in person on the said date fixed.
Their personal appearance may be dispensed with the police.
though the defendant number 1 and the content number 1 and 2 appeared in terms of the order passed by this court in person, and the learned advocate is appearing and prayed for time to file affidavit in opposition. For the time being, the personal appearance of the defendant number 1 and 2 are dispensed.
Dismissed with Lordship.
Grateful.
Granted, Lordship. It is my pleasure, Lordship.
Next.
I appear for the petitioners. One of the 3 applications are appearing in the list. This is that matter with that restaurant in Park Street. That matter was mentioned before, Lordship, whatever, my lord. Today, my lord, in the list, the GA4 is appearing, but my lord's last order record that GA4 is disposed of. That correction has to be done, and the interim order is still today in my injunction. And the other 2, which is GA2 and GA3, is my learned friend's application, section 10 and order 39, rule 4.
3.
That's 3.
Yes.
So, and if they proceed, or
Your Lordship,
Mr. Kasimuddin told me that he will be stuck somewhere, my lord.
yes. Your Lordship, 2 application under order 6, rule 17 are
What has
still
happened to the City Civil Court?
And the next date is fixed on 7th of April.
27th.
No, 7th.
7th April.
Yes.
So I am
So
fixing
kindly fix a date after that.
that.
Yes, 16th or 17th of April will be fine.
So I am fixing a date for hearing.
Yes, sir.
And affidavits completed.
Yes,
All,
yes,
all.
completed, and my lord's last order compliance has been done. Part compliance,
Yes,
the
we have
payments.
paid. Yes, for this month.
Part compliance done. Part compliance.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Counsel for the party submit that pleadings in connection with GA1, GA2 and GA3 have been completed and ready for hearing. But the learned counsel for the defendant submit that the connected matter is pending before the City Civil Court, which is fixed on 7th of April 2025 and place for fixing the matter after 7th of April 2025. In view of the above, let the matter give the date for hearing. And what is the date?
Anything.
Yes. First of no 7 after 7th April.
So, Your Lordship, 16th or 17th will be.
After.
उनको तो वहाँ का ऑर्डर पास होगा, टाइम लगेगा. और मई में क्या है? सेकंड लास्ट वीक में देखो 2 बजे 3 बजे कुछ है लास्ट वीक में. लास्ट वीक फुल. हाँ 28th April at 3:45. मुश्किल.
RAC ticket.
6th of May at 6th May 3 p.m.
3 p.m. I mean, Lordship, look at the GA4 is appearing in the list.
It is fine from the record. The GA4 of 2024 has already disposed of. Full stop, but it has been showing in the cause list. Accordingly, the department is directed to take appropriate step to delete the GA4 of 2024 from the cause list.
Interim order be extended. It's till today.
Counsel for the plaintiff submit that interim order granted Delhi is going to be expired today and paid for extension of the interim order. The interim order is extended till क्या date था?
6th May.
6th May.
Time ta koto?
2025.
Next. Oblige me. Interim.
For the plaintiff.
Yes, sir.
I mean, the last order of your lordship was that all the defendants were served excepting the defendant number 2. Although they carry on business in the same place, but in order to avoid any
the publication was made.
Yes, and then the publication has been made. I was now praying for subject to lordship sanction. Now that I am to obtain an ex parte decree in the event of this day, kindly fix a date for ex parte decree, my lord, and I shall obtain.
No, but when the publication was made?
Yes, kindly fix.
27th February.
27th February.
Both.
So Hindu and Bhartavan.
I am doing one. I am fixing after 10 days. You obtain the report from the department whether anybody is appearing after this this publication.
Then fix a date for you.
Then I will fix it.
I will do that. We have been harassed by the defendant for a long time. Several orders were passed.
Since appearing for the plaintiff. The plaintiff has filed affidavit of service enclosing the original paper publication showing that in terms of the order passed by this court dated 14th February 2025, the notice was published for the purpose of information upon the defendant number 2. First. Let the affidavit filed by the plaintiff be kept with the record. The counsel for the plaintiff prays for time to ascertain from the department whether the defendant number 2 entered appearance or not.
Or any of the defendants, not any of the
Whether the defendants have entered appearance or not.
Exactly.
In view of the above, the plaintiff is directed to produce the report from the department to show whether the defendants have entered appearance or whether they filed the written statement or not. This is the matter on the commercial on 18th of March. No, आज कितना तारीख है? 13 है? नहीं होगा. 25th March.
My application for additional evidence, commercial suit. So that is the problem. Actually, before trial has started, we with the affidavit of evidence, we have
the document with the newer possession or
no, that I have said specifically. Out of the 5 documents, 4 are not in my possession. 1 was with my possession, but that we could not trace it. We found it afterwards. Now they said they want to use an affidavit in opposition. Now the flip side is this: the time is expiring on 25th of March for the commission. Lordship has extended the time. The dates are fixed on 18th, 19th of March. Now, Lordship, I will humbly pray today if we can proceed with the examination without prejudice to the outcome of this application, and Lordship can give directions for
you will not rely upon this document.
Well, I shall rely upon it, but then subject to outcome, because then they can then they may examine this may get expunged. That's all. Otherwise, it will be my evidence can't be fully cross-examined. My affidavit evidence is there.
Why you want to file affidavit?
My lord, first of all, this is just not belated. This is legally also not sustainable. I will evince the same. If your lordship gives me an opportunity to file an opposition, one after another I will show. I do not like to open the very defense of it right now. My lord, my lord decides. After that, my lord, let me give the oppositions, my lord.
When the evidence is fixed before the commission.
My lord, this has been also a situation. My lord, the judge's brief of documents has been filed a long back. Thereafter, suddenly, why my learned friend is referring to that, when the evidence is filed, a certain fresh document has been filed without even taking leave of this honorable court. And now that they have stated that while writing this evidence, certainly we came to understand that these documents are necessary.
That is always the case. While preparing the evidence,
let me. Now, my lord, this is not something, if it is not in the pleading.
I know.
Now, we have not dealt with,
okay,
I do not want to discuss all this right now.
Then that is to be, you are for the
Yes,
defendant.
I am for the defendant.
That is to be
Give me an opportunity to file and...
How soon you will file?
My lord, just let me, my lord, the coming week, my lord, a bit stormy. Stormy in sense that the leave and this and that, my lord. And this is a case
Leave
of...
is good for the advocate to work in the chamber.
No, my lord, but the officers of this defendant, my lord, they're central government employees, my lord. So kindly extend 2 weeks after that. So give me...
Insurance company 24/7, they will...
Yeah, I know, my lord, please. I'm known, not 24/7, my lord. They are the very happiest people, so far I understand. So therefore it is not, my lord, 25th is a returnable date, my lord, of this. 25th is the returnable
evidence, and the 18th, 19th are the dates fixed for the evidence.
My lord, let it come after 3 weeks. I will prepare the opposition within that. My lord, since I am praying for that, since the coming week, my lord, a bit disturbing for me also. So give me 2 weeks more time after this week. So, my lord, there is voluminous, because if it apparently shows, my lord, 6 documents, but if your lordship will see, this consisting of more than 2,000 pages, not appended with this, that I will take a defense also. They have filed it with the evidence. I will show you that. Had they been so fair, they could have annexed all these documents with this, but they have not. They have not done this, my lord. They have taken another survey report which is not pertaining to this case as a document to this. Why I have allowed this or that. I do not want to express all this, my lord. It has to be dealt with.
Suffering for the defendant. Police of plaintiff has filed an application being GA Com 5 of 2025, praying for leave to disclose additional document. Police counsel for the defendant raise objection and prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. A reply, if any, there to be filed within
1 week.
1 week thereafter. Full stop. List the matter.
So that'll become next month.
List the matter on 8th of April 2025. Full stop. It is informed to this court that the learned commissioner has fixed the matter for examination of the witness of the plaintiff on 18 and 19.
Yes, ma'am.
18 and 19, but the plaintiff intend to rely upon the document which he has pressed for leave to bring on record. Accordingly, without the document, can the chief be continue? No.
So they have to, but chief can be done in no time, but they cross. It is there.
No, that's not that, my lord. So far, my understanding goes the exhibit has also to be made accordingly.
Without prejudice.
No, without prejudice.
And 19.
In law, it's not arbitration.
March 2025. But this.
Plaintiff can reply upon the.
Then no, 18 and 19 March 2025. But this court is of the view that this application, this application is to be heard first, then the examination in chief of the plaintiff witness can continue. Accordingly, the commissioner is requested to lay his hand till the disposal of the application. This is the matter on 8th of April 2020.
Yes.
Grateful.
Grateful.
My lord, I'm for the plaintiff, my lord. This is my affidavit of service, my lord. It has come back as door locked unclaimed, my lord. The defendant. What I've done, my lord, I have scanned the application and along with the notice of motion, and I've sent them through email also.
So
I would kindly take the page number 7 is the postal, my lord, original postal, my lord. It has been written that unclaimed. And my lord, behind that it is written door locked. Twice they have gone to serve them. Door locked, my lord. But the address that I've sent, my lord, would appear from my lord, the application, my lord.
Written unclaimed.
Yes, my lord.
Out of delivery. Then
my lord, kindly see 139, page 139 of my application, my lord.
139 of application.
My lord, I've sent the demand notice in that same address that was delivered confirmed.
Correct.
But they have deliberately not taken, my lord. 144 is the tracking report. It says item delivery confirmed. But that delivery also, my lord, would kindly see.
Item delivery confirmed. Yes.
My lord, page on that 2 line below, item returned refused. They refused the first time. Thereafter, they let them deliver it. But this time they have door locked and unclaimed.
So what do you want now?
A door locked is a good service, my lord.
Door lock is good service.
Yes, my lord. May I proceed with the matter, my lord? I'm paying for a summary judgment. This is my chapter 13A application, my lord. What has happened? The plaintiff is in the business of
what is application?
Summary
What is
judgment
application.
Summary judgment application under chapter 13A, my lord.
Summary judgment.
Yes.
Writ of summons served. Then defendant is not appearing because they have refused whether writ of summons is served.
But that I've taken.
The
scrutiny has been completed, my lord.
Without writ of summons, if the defendant is not appearing, I will not take the chapter 13.
I will kindly keep it on the next week. I will intimate whether the writ of summons has been served or not.
Sensation supreme for the plaintiff. Plaintiff has filed the affidavit of service showing that the notice of the present application was served, sent to the defendant, but has been returned unserved as unclaimed. Counsel for the plaintiff submitted that the plaintiff has also sent the copy of the application along with the documents through mail, but in spite of service, but none appears on behalf of the defendant. So the counsel for the plaintiff has filed the present application under chapter 13A.
Yes, sir.
Under chapter 13A of the original side rule of this court. So the counsel for the plaintiff prays for time to ascertain whether the writ of summons is served upon the defendant or not. In view of the submission made by the counsel for the plaintiff, the case is adjourned.
2 weeks.
Appear on 28th
March.
28 March.
I am for the defendant one, man.
Who is for the plaintiff? Once the matter is fixed, the new motion and all these things, nobody is appearing. If I will take the hearing matter, then advocates are telling that this court is taking the only hearing matters, the new motion is not been taken. Since morning, none of the advocates is ready for the hearing of the new motions. So only for the clerical purpose, the court will sit here. If I continue with the hearing matter, then the advocates will say no, new motion is not taking. Yes, who is for the plaintiff?
I'm for the defendant, man. Defendant one matter.
What is the matter? GA com. What is the GA?
The GA have served.
Not served.
Not served.
So and so appearing for the defendant number?
1.
Defendant number 1. None appears on behalf of the plaintiff and other defendants. For the interest of justice, the case is adjourned. Let the matter appear in the combined monthly list of June 2025. Yes, next.
Lord 19, I appear for the petition of plaintiff in the matter. This is an application, my lord, praying for decreeing of the suit on the terms of settlement filed between the parties, my lord.
Where is the settlement?
My lord, annexure A to the application.
GA1, GA3?
GA3, my lord.
Terms of settlement?
Terms of settlement
What is the
executed.
suit for?
Suit for, my lord, recovery of money on account of maintenance charges in respect of a property leased out.
Leased property.
Property, my lord, thereafter the pro forma defendant is the owner of the property. My lord, there is a suit decreed in part.
17,23,919.
My lord.
Along with 12% interest. So how much amount you have settled?
I have to pay, my lord, another 5 lakhs.
You are for the?
Plaintiff.
You have to pay?
My lord, rehabilitation charges. I'll indicate to your lordship what had happened is, the pro forma defendant had let out the property. I being the, my lord, the maintenance person was maintaining. I filed an application, order 12, rule 6, judgment upon admission, decree of 8 lakhs, traveled up to, my lord, division bench, confirmed.
In your favor?
In my favor. Thereafter, my lord, since, my lord, the property was not being vacated, ultimately, my lord, we had to enter into a settlement. At least today we have the property with us. We had paid, my lord, a sum of 5 lakhs.
So after paying the amount, they have vacated the premises.
Yes, they have vacated.
That is the thing. And you are taken possession.
Yes, my lord.
So you are only maintaining. How you will take? You are
My
not
lord,
the
the
owner.
pro forma defendant here has taken possession. The terms of settlement
Who are
records
you?
that. I am the plaintiff, my lord.
Who are you?
The plaintiff. The
plaintiff, who are you? You are not the owner.
I am not the owner. My lord, your lordship would kindly see, I am the wife of the owner.
You are the wife of the owner.
Wife of the
And
owner.
you are maintaining the premises.
Maintaining the premises.
Good.
My lord, the terms of settlement.
Where is the terms?
My lord, annexure A to the application.
A, B, and C.
Is my lord is appearing for the defendants.
Lordship settlement has.
Whether look, lucky person, plaintiff has paid the amount to the defendant.
Lordship.
Yes, where is the term?
Terms, my lord, your lordship will find at annexure A. The page.
Defendant surrendering the possession.
Terms of settlement. After the affidavit portion, the terms of settlement, your lordship would kindly see.
Defendant 1, 2, 3 agreed to surrender the vacant cast possession of the premises described Schedule A to the performance defendant. As a consequence, defendant surrendering the Schedule A in favor of the defendant, plaintiffs shall forego her claims. So A, B, and C.
A, B, and C, man.
Plaintiffs also filed other litigations which the parties shall withdraw. Where is the litigation? SLP?
SLP, my lord, I indicated to your lordship, my lord.
And
my
AP?
lord's judgment had taken.
Arbitration also?
Arbitration petition also, my lord. All arbitration and other things are also being withdrawn.
Also surrender the existing certificate enlistment. Parties.
There were criminal cases filed by and between the parties, all of that being withdrawn, my lord.
So and so appearing for the plaintiff. So bring for the performer defendant or defendant?
Defendant.
Defendant. Nobody's performer defendant. Full stop. Who has signed this agreement?
My lord, all the parties to the suit, my lord.
The plaintiff has filed an application being GA Com 3 of 2025 disclosing the terms of settlement entered between all the parties, that is the plaintiff, comma, defendant number 1, comma 2, 3, and the performer defendant.
And 4, my lord.
1, 2, 3, and performer defendant. Defendant number 4 within bracket performer defendant. 1, 2, 3 within bracket performer. Full stop. The counsel for the parties submit that the parties have settled the dispute with respect of the terms of settlement, and as such, this court can be this suit can be disposed of in terms of the settlement entered between the parties dated
27th February
27th of February
2025, my lord.
2020. So, consider the submission made by the counsel for the plaintiff parties peruse the terms of settlement. This court find that there is no impediment to accept the terms of settlement entered between the parties. Accordingly, in terms of the settlement entered between the parties, CS Com
768
of 2024 within bracket CS number, old CS number 2022 of 20222 is disposed of. Full stop. Is disposed of. The terms of settlement, full stop. The decree be done accordingly. Decree be done accordingly. Terms of settlement dated 27th February 2025 be made part of the decree.
Deeply obliged.
Any order, interim order? Nothing.
Deeply obliged.
GA Com is disposed of. Accordingly, GA Com is also disposed of. Yes.
I appear on
20, my lord, I appear for the petitioner.
My lord, I appear on behalf of the petitioner, my lord, beg to assist your lordship, my lord. This is where an interim order had been made by your lordship, my lord, and then, my lord, notices have gone out to all. 2 of the defendant respondents have already filed their affidavits in opposition. My lord, by a previous order, my lord, was pleased to grant liberty to the others who had appeared and sought extensions to file affidavit in opposition, the liberty to do so, and a liberty to me to file a comprehensive affidavit in reply. Now, Lord kindly sees my lord's order dated 31st January 2025. That has captured, Lord, the appearance of all the parties.
Yes.
And if your lordship sees, there's also a direction for the 1, 3, 4, 8, 9, 10, 12, and 13. There's a liberty to file their affidavit in opposition within 2 weeks from that date, with a liberty to me, cross liberty to me, to file a comprehensive reply to all the affidavits together for the sake of ease of handling. Now, Lord, the other affidavits, Lord, have not yet come in. 2 of the affidavits have come in.
9 and 12.
Mala, I am appearing for HDFC Bank. My affidavit has been filed.
My lord,
My lord,
I appear for the respondent number 9, my lord. My affidavit in opposition has already been filed.
Sarna, just Mr. Mukherjee say.
Lord, I am for the main respondent. Lord, my affidavit is with me. It's ready.
No, but Mr. Chaudhary is not the main respondent. He's one of
the main supporting respondent.
He's one of the main counsel, but his client is just one of those respondents.
Lord,
main supporting. In fact, Mr. Chaudhary's client has defrauded the bank, HDFC Bank, of hundreds of crores of rupees. I am the main person who is aggrieved.
Sharma, senior is appearing. He is making submission here. Yes.
Mr. Sharma, we are in Kolkata still. Huh? We haven't gone off to Delhi.
No, sorry, I did not see Mr. Mukherjee.
Yes.
Now, my lord, HDFC Bank, my lord, is the main, my lord, party against whom, my lord, reliefs have been granted. My lord, ex-party. My lord, we filed an affidavit in opposition. My lord, whether others file or not, kindly, my lord, take it up. And my lord, let Mr. Chaudhary, my lord, also file his, my lord, affidavit. And may he give a copy to us also.
I'll do that.
Because I'll tell you, lordship, why. My lord, our case is going to be that, my lord, the plaintiff and Mr. Chaudhary's client, my lord, are running on the, my lord, same, my lord, boat. my lord, they have, my lord, actually supported each other, and the others are not filing an affidavit because, my lord, they're supporting the plaintiff and don't want a hearing.
So you are the main.
My lord, kindly, my lord, let them give me a copy, and my lord, your lordship keeps it any date. It won't take more than 15 minutes. My lord, I'll tell your lordship why. Because there are orders, my lord, in earlier proceedings, my lord, apropos, my lord, this matter, which will show, my lord, that this order could not have been obtained.
My lord, may I just say this? My lord, apart from the last sentence, my lord, that the order, my lord, should be vacated, I don't agree with Mr. Mukherjee, but I want to surprise him by also, my lord, opposing the the continuation of the interim order which has been passed. My lord, I am fighting with Mr. Mukherjee separately. I've got my own suit where, my lord, this plaintiff has also filed an application for intervention, which is pending. My lord, not disclosing most of that, my lord, interim order is obtained from your lordship. There is no necessity of any interim order. He's come after, my lord, 3 years. No question of, my lord, any sort of apprehension, my lord, can arise also. I am, my lord, ready to just indicate the basic facts to your lordship now. What had happened, my lord? Actually, I am also, my lord, I've been
My
saying.
lord, apart from, I hate to interrupt Mr.
It happened, my lord.
But you're innocent.
Innocent. I'm
Yes,
said to be a fraud.
I hate to interrupt Mr.
Sir,
Chaudhary.
I'm sorry,
The
my
only
lord,
thing
but
is
may I
that
just
I am not,
never had a chance
Mr.
on
Chaudhary,
the
just a
first day,
second.
my lord.
Okay,
Mr. Chaudhary, just a
You
second.
have filed the affidavit.
Yes, but may I
Have you
just
served
take
the copy?
1 minute, my lord?
I agree with
Never had a
everything which Mr.
chance on the
Chaudhary has
first
said,
day, my lord. It was sought to be moved ex parte.
I
My
agree with,
junior came asking for a copy. Interim order was granted. I'm not, my lord, saying it's not possible. It's
they were
always.
not on caveats, they
But
appeared.
I'm always
He argued.
entitled to come back and say that
Yes.
perhaps, my lord, the interim order should be vacated.
Yes.
Now, please, Mr. Banerjee.
No,
Now,
Mr. Chaudhary, just 1 second. You have said that I have suppressed the fact of pendency of the earlier
your
proceedings.
client
Let
has.
is
I have no allegation
the court
against
is
you.
not
You're
going
my
to pass
friend.
any other without hearing all the parties. Let
Yes, my
Chaudhary
lord.
complete his
Now, my lord, what had happened here is that I am a stockbroker. My lord, all stockbrokers at that point of time was, my lord, carrying on a format of business. They would, my lord, take money from, my lord, banks, like, my lord, HDFC Bank in this case. I had obtained, my lord, a loan from them. This, my lord, loan was used for the purpose of allowing, my lord, my clients to, my lord, trade and purchase shares. Normally, we pay for the shares we purchase in, my lord, 2 days. It's, my lord, called T+2. 48 hours you have to pay for your trades. But the benefit we gave our clients was that we would, my lord, from the money obtained from Mr. Mukherjee's clients, my lord, we would, my lord, pay off. And the shares were kept in the general pool account of the broker. That's me. So, my lord, using the bank loan, a client like, my lord, the plaintiff could buy shares, and the shares which were bought would be, my lord, kept in the general pool account. These shares would be pledged to the bank for the purpose of, my lord, securing their financial assistance. So I had a, my lord, huge loan with HDFC Bank. And, my lord, what had been done was all shares with the money, my lord, got from them, purchased for my clients, were kept in the general pool account and pledged. One day, my lord, SEBI comes up with a notification that if you buy shares for your clients, it can't be in your general pool account. This is for all stockbrokers, and it has to go back to the client's demat account. So this format of business, my lord, came crashing down because I had to, my lord, send these shares to the demat account of the clients. HDFC, my lord, became immediately very wary because I had 100 crore outstanding, and, my lord, the pledge would be meaningless. So, my lord, they sold off the shares and terminated my account. I have a separate suit against HDFC claiming damages for destroying my business. Now, it's a different matter that these shares were sold off by HDFC. The plaintiff, this was pledged. Now, the plaintiff, my lord, it was purchased for the plaintiff. It was their shares, so they have a claim against me. Now, the question is, what happened thereafter? The stock exchanges have, my lord, taken remedial action. There are arbitrations. They have gone to the stock exchange and, my lord, they have obtained some compensation from there. There is a suit filed in Bombay High Court by, my lord, the stock exchanges against me. There, my lord, I have had my bank accounts and everything are attached. Now, this is going on for 3 years. All of this needs to be considered before, my lord, interim order is granted.
Okay.
Now, without disclosing anything, now he knows everything because in my suit against HDFC, he's applied for intervention. He's participated in hearing before the division bench. He's participated in hearing before the single bench. Application is pending. Without, my lord, appraising everything, the interim order is obtained.
Okay.
And there is a Bombay High Court order also covering the same field. So,
Okay.
my lord, I have indicated that. I am also requesting, my lord, for my lord, a data, and most importantly, a client, my lord, does his transactions with the company. Here, my lord, the purport of the interim order is personal accounts of, my lord, all the directors of the company are also attached. My lord, there is no cause of action against them.
Yes, yes, yes. There is no cause of action.
That's why, my lord,
Fraud is not an important cause
kindly
of
hear
action.
it.
Because there's an order, my lord, of the Securities Appellate Tribunal, and my lord, the properties in respect of which, my lord, they've obtained, my lord, orders, my lord, are not their properties also.
And most importantly, my lord, I can understand, my lord, that he has a money claim against me in a matter like this. The account, my lord, of the broker, the stockbroker, the company, my lord, BRH may be attached, but they have no cause of action against, my lord, every director.
Egregious fraud. Egregious fraud is the cause of
Where
action.
is the fraud?
Egregious fraud. Not only fraud, it's egregious fraud. And you are a nationally recognized fraudster.
4 and 8.
Recognized in Bombay, recognized in Calcutta. Very soon will be recognized in all the states of India.
Supreme for the 12. Supreme for the 13 and Supreme for the 18.
Permitted to mention.
You are appearing for?
On behalf of the respondent number 10, Lordship. I'm praying for extension of 1 week, Lordship. My all affidavit opposition is ready, Lordship.
My lord, we are suffering the order, my lord.
Signatory authority is out of town, Lordship. We are not able
Why
to.
you not file the affidavit?
Lordship, he is out of town for his own marriage ceremony, Lordship. So I'm not able to get it signed by his.
My lord, insofar as, my lord, we are concerned, kindly take it up for hearing.
No, this cause Mr. Chaudhary cannot oppose. If it is his own marriage ceremony, how can Mr. Chaudhary oppose?
No, I'm not opposing.
But the marriage didn't, my lord, happen, my lord, over a period of almost, my lord, 6 months.
No, but then I also did not get myself engaged in a marriage. I got an interim order from court and I got it extended lawfully.
That's fine. So marriage can't now. I'm opposing.
Who has filed, Mr. Chaudhary, you have filed the affidavit in 11. You are for the HDFC.
My lord, I'm for HDFC.
Mr. Mukherjee is leading me, my lord. We are for HDFC.
3, 4. Chaudhary, you are appearing for?
1348.
13. Counsel for the defendant number 1348.
Lordship, if I be permitted. Lordship, I'm appearing for respondent number 13. We have our affidavit in opposition ready. We would like to serve the copy, but will be filed by Monday because it's coming. It's on transit from Delhi. It's been notarized there.
For respondent number 12, I have already filed my opposition. I appear for Securities and Exchange Board of India.
Defendant number 1348, defendant number Mr. Mukherjee, you are also
11, my lord. 11. I filed, yes, yes.
Defendant number 11, and you are appearing for?
My lord, I appear for the respondent number 9, my lord. I have already filed my affidavit in opposition. It has been served, my lord, upon the plaintiff.
Defendant number? Mr.
9.
12.
My lord, I am for the petitioner.
Defendant number 12. Any other have filed affidavit? No. Have filed their
1, 9, 11, 12, and 18 have filed, my lord.
1, 9, 11, 12, and 18. Correct. Have filed their affidavit in opposition. You filed the reply?
No, my lord. We'll have to seek an
Full
extension.
stop. Counsel for the defendant number?
10.
10.
13.
And 13. You will not file affidavit. You file. No. So, defendant number 10 and 11.
10 and 13.
10 and 13. Wait for time to file affidavit in opposition. Full stop. Let affidavit in opposition file within a week from date after serving the copy to the learned counsel for the plaintiff. Full stop. Full stop. The plaintiff is directed to file the affidavit. File the composite reply of all the affidavits within a period of 2 weeks thereafter. Full stop. List the matter. Give the date. Any date can be given. No, अप्रैल में है कोई डेट 2 week 3 weeks 4 weeks में अप्रैल में देखो कब है? 7th April at 3:45. कितना? It will take time. Can it be fixed 2 dates? But it will go in.
Yes, my lord can do that. This is going to take some time.
No,
Very heavy matter.
Let the matter appear on. The commercial है ना? 14, 15, 16 सब छुट्टी है. 21 and 22 April at.
Grateful, my lord. We'll come with
21.
a note and finish it in half an hour.
Yes, Mr. Chaudhary will finish it in half an hour. Mr. Chaudhary will finish it in half an hour. Yes.
21 and 22 April.
My lord, can 20,
Obliged.
my lord, and any other date instead of 21, my lord.
My lord, could it be 28th, my lord? 28th.
Okay, 29.
28,
28, 29. Grateful, my lord.
My lord, the
Please,
interim
please
order-
extend the interim order.
For the plaintiff prays for extension of the interim order. Interim order is extended till 29th of April 2025 or until further order, whichever is earlier.
Deeply obliged.
Grateful, my lord.
Very grateful, my lord. With your lordship's kind leave.
Thank you. Yes.
My lord, before my lord takes up the testamentary matters, my lord, may I only mention my my other side is here, my lord. Item number 13, which I sought your lordship's leave to withdraw. My lord, I misheard, my lord. Lordship had asked me if I was seeking liberty. My lord, I had heard leave, my lord, which is why I missubmitted, my lord. I was seeking liberty to file afresh because they have already filed in Gurugram, my lord. So, my lord, I will be contesting there, my lord. In case there is any counterclaim, my lord, that should not be barred, my lord.
There is no problem. You withdrawing of this suit and filing counterclaim.
My lord, in case it gets, my lord, I have withdrawn. Lordship has recorded that. My lord, only the liberty in case any other proceeding is given.
I don't oppose, but
withdrawal वाला कौन लेता? Item number 13.
OCD 13, my lord.
আমার নামটা তখন ছিল না, দিয়ে দেবেন তো।
For the liberty, the suit is dismissed as withdrawn. Liberty to file afresh if any occasion arose.
Grateful, my lord.
Liberty to file afresh if any occasion arose.
I'm grateful, my lord.
Kindly, my name can be. I was not there.
Defendant का नाम भी लिख देना. Counsel for the Mr. Sarkisian, learned senior advocate appearing for the defendant.
Grateful, my lord.
Item number next 24. 24, my lord, that order 7 11 matter. I will only require 10 minutes, my lord, if your lordship gives us any time.
24.
Not more than 10 minutes.
24.
Yes, my lord. That order 7 rule 11, my lord.
Come on Monday.
Yes.
It will, because I don't think today it will be taken.
No, can it be at 1 o'clock, my lord? We can finish it.
That I can't say.
No, unless your lordship fixes a time, my lord,
Yes,
it is very.
It is fresh in your lordship's mind.
That's correct. That's correct. But 1 p.m. because my testament is 12:30.
Then, my lord, at
11:30, my lord.
by the clock 10.
Then 11:30 कुछ है नहीं है. 11:30 already fixed.
2 o'clock, 3 p.m.
Anytime.
All fixed. सब है कोई ट्रिप हैं? ना वो फिर मुश्किल हो जाएगा.
Tuesday, also Tuesday.
Tuesday भी है. 11:30 है. Tuesday 11:30.
Obliged, my lord. We shall come with our notes, my lord, and we can.
Item number 24. So item number 24. So appearing for the plaintiff. So appearing for the defendant.
Are you going to cite any more judgment?
So the matter is fixed today as item number 24 under the heading adjourn motion, but due to paucity of time, matter could not be taken up for hearing. Let the matter appear on 11th March at 11:30.
Deeply obliged to you.
I will not take much time, only 10 minutes.
Come with the return.
Yes.
The next matter was, my lord, an application for extension of time. It's expiring on 12th of March. Application for extension of time to put in written statement expiring
one?
on 12th 21. He's here. He's not opposing, my lord. This application can be allowed.
Only thing was the directions for discovery inspection.
A commercial matter.
Commercial matter
within 120 days.
Within 120 days.
Give. When the writ of summons was served,
my lord,
you are appearing for all defendants.
This is for all the defendants. Yes.
All defendants.
Yes, ma'am.
When the return of
my lord, 12th of November 24, it was served. 14th of November 24, I entered appearance and I affirmed the written statement on 25th of February 26.
12th of November.
Yes, my lord, takes page 33. That's the entering, my lord, report of the deputy registrar where
33.
I have 33. 14th of November, I entered appearance after I received the summons on 12th of November.
12th of November.
Yes, my lord.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Full stop. Defendant has filed the present application being GA Com 4 of 2025, praying for extension of time to file return statement. Counsel for the plaintiff submit that the writ of summons was served upon the defendants on 12th
November 24.
12th November 2024, but due to 12th November 2024 and on 14th of November 2024, the defendants have entered appearance. Full stop. Full stop. Subsequently, the non-advocate on record of the defendant has directed the defendants to bring all the documents for preparing the written statement, but the defendant could not produce the document within the prescribed period of 30 days, due to which the defendant could not prepare the written statement. But the defendant has prepared the written statement and affirmed the written statement on 25th of February 2025, that is within the outer period of 120 days. And as such, he prays for acceptance of the written statement. Full stop. Learned counsel for the plaintiff. Yes, what is the submission?
Well, I am not opposing only my lord.
Counsel for the
discovery inspection.
counsel for the plaintiff, there is no objection and submitted that though they have not filed the written statement within the period of 30 days, but have filed the written statement within the outer period of 120 days, and as such, the same can be accepted subject to payment of cost.
My lord had said there is no provision, my lord, when I was, my lord, opposing.
So no. Data commercial, non-commercial, there is no provision.
I leave it to my lord.
Full stop. Full stop. At the learned counsel for the respective parties, this court find that though the plaintiff has not and defendants have not filed the written statement within the period of 30 days, but have affirmed the written statement within the outer period of 120 days and filed the same before the department after getting leave from this after the leave from this court. Thus, this court is of the view that one opportunity should be given to the defendants to file written statement subject to payment of cost of rupees 2,000 in the State Legal Service Authority within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny by the department. Full stop. The defendant is directed to place the evidence to showing that the cost has been paid by the defendant in the State Legal Service Authority within on the next date fix. Full stop. Counsel for the defendant, full stop. As the counsel for the plaintiff submitted, as the written statement is accepted, accordingly direction may be given to complete the discovery and inspection of the document. In view of the above, the parties are directed to complete the discovery and inspection of the document within a period of 3 weeks. Full stop. Affidavit of admission and denial of be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to complete the discovery to exchange the suggested issues. Full stop. Please the matter on 2 weeks, 1 week, 3 weeks. This is the matter on 22nd April 2025 for framing of issues. GA Com 4 of 2024. This program.
Item 9, my lord. Item 9, my lord. The special officer's report is. Apologize, my lord.
Give.
The pictures are there, my lord, of the.
Where you mention, which paragraph?
Page 2, my lord. Page 2 at the top, my lord. I've listed the 3 properties, and my lord, the second paragraph, I've mentioned one property which has been taken possession of, which is 40B.
Where you mentioned?
My lord, para 2, my lord.
Para 2 in person you visited.
Yes,
three property.
Fifth line from the bottom, I proceeded to close the collapsible shutter at the premises and place my padlock therein to take possession of the said premises.
I therefore proceeded to close the premises and padlock in next night. So two property has been closed.
Yes, my lord.
And one is not seized.
One is not seized, my lord.
I have filed my terms of settlement, my lord, as active.
So appearing for the plaintiff, so appearing for the defendant. The receiver is also present. The receiver has filed the report. Let the same be kept with the record. Full stop. Counsel for the plaintiff has defendant is there.
Yes.
The counsel for the plaintiff has filed the affidavit of filed these terms of settlement, wherein the parties have settled the dispute for a total sum of rupees 23 lakhs, and the defendant has paid the said amount to the plaintiff on 3rd of March 2025, and as such the plaintiff is not intending to proceed with the case further. Full stop. The receiver has filed the report and submit that
page 4, my lord, page 4 has the two properties.
And submit that as per that he has inspected the premises and found 3 properties of the defendant. Accordingly, 2 properties were seized by putting the padlock in the said premises, in the business premises of the defendant. Police and one property was not premises has not yet been seized. Full stop. As the parties have settled them, full stop. This it is found that the plaintiff has claimed the total amount of rupees 44 lakhs 44,00,090 along with interest. But now the parties have settled the dispute for a total sum of rupees 23 lakhs and the defendant has paid the same. Accordingly, both the parties have entered into a terms of settlement dated. What is the date?
Third of March.
Where it is?
The date was not
have entered terms of settlement. Considering the above, this court find that there is no impediment to accept the terms of settlement entered between the parties. The plaintiff has accepted the total settlement amount of rupees 23 lakhs, which has been paid by the defendant, and the plaintiff submit that he will not claim any further amount from the defendant. Accordingly, the terms of settlement is accepted. CS number 664 of 2024 is disposed of in terms of the settlement entered between the parties. Let the terms of settlement be made part of the decree. Full stop. As the receiver has seized the 2 shop rooms.
Yes, my lord. Shop rooms, page 4, my lord. It's
2 shop rooms that is situated at 40 capital B, Ustad Inayat Khan Avenue, Kolkata 700017 and IA 1A, Circus Market Place, Kolkata 700017. As the parties have settled their dispute by entering into the terms of settlement, and the defendant has paid the total settlement amount of rupees 23 lakhs to the plaintiff, and the plaintiff has accepted the said amount. Accordingly, the receiver is directed to open the padlock of the said premises and to hand over the same to the defendants, and the defendants are free to use the said premises without any hindrance.
My lord, the keys are with me, my lord. Should I hand over?
Handed over to the defendant is there, and the
In the open court, the receiver has handed over the keys of the said padlock of the premises to the learned advocate for the defendants, and the defendant has accepted the said keys. Accordingly, the defendants are liberty to open the shop room and to utilize the said shop room for their business, for their purpose. Full stop. Paid amount.
My lord, I have been.
the report of the special receiver we kindly circulate.
The receiver is directed to the report filed by the receiver is kept in the record, and the parties are directed. The receiver is directed to circulate the report to all the parties, to all the appearing parties.
I apologize for my
Police CS com census disposed of. Accordingly, GA com is also disposed of.
So great.
Great.
I am appearing on behalf of the propounder, Your Lordship, on the plaintiff. It is coming up for the discharge of the administrator, Your Lordship. We have no objection with regard to the report filed.
Report? Who has filed the report?
No, the accounts, I apologize, Your Lordship. The accounts filed, we do not have any objection to that. We have taken, I have taken instructions from the plaintiff.
Huh? Where is the report?
Lordship, I filed the accounts. I was directed to file the accounts till the month of February by 4th of March, which I have done. Lordship, this is, I'll just hand over.
Order, okay. Administrator, accordingly, administrator directed to file detailed accounts of till accounts till the month of February 2025 or yes. So you have this is up till
28th of February.
Where you mention?
Lordship, if your Lordship comes to page number 3, Annexure A, as well as in the first paragraph at page each one.
The accounts you have to annex the account the rent of areas. Petition being premises number 28 February inclusive of contents. How much amount is lying in the account?
Lordship, 72,809.
So where is the how many tenants are there? You're not issued the rent receipts.
Lordship, no one is residing there anymore. Only one tenant is there. He is not giving any amount, and the building is in very bad condition. That's why nobody has paid up. So no
How
rent.
this amount has come?
This is from the previous, the last collected account, last collected rents.
2020.
Which was in the month of March 2020.
Correct. That's why I'm asking where is the account book?
Lordship, I have the accounts book. I have annexed for the month of March 2020. I have annexed.
Madam, you have been appointed when?
In by an order of
April 2015.
20th April 2015.
20th April 2015. Correct. When you have taken the accounts on your hand, when you open the account.
I have opened the account.
You could have given. That's why I ask. You have to give the total details. Otherwise, you will be in trouble in future.
In July 2015.
In July 2015, what amount was there in the account?
What I had received was 61,630, which I have filed for when I had filed accounts for November 2015. I have filed these details. Yes, I have filed every 6 months. I have filed all the details with the rent receipts as well as the bank statements.
Okay, I am calling for the report. So-and-so appearing for the petitioner, so-and-so appearing for the administrative pendant client is appearing in person, is also appearing. Full stop. In terms of the order passed by this court dated 13 February 2025, the administrator has submitted account before in the department up till 28th of February 2025. Full stop. In view of the above, the department is directed to submit report before this court, whether the total report has been filed by the administrator or not. Let the said report be filed by 7 by 17th by 24th of March 2025. Let the matter appear on 24th. No, ये तो हुआ है.
Obliged.
Testamentary Friday आएगा 28th. Come on 28th. I will see it. So then another administrator is to be appointed.
Lordship, I'll take instructions on that.
What is your remuneration?
Lordship, 3,500.
Have you
No, I have not charged the remuneration for the past 3 or 4 years.
that is to be adjusted.
Lordship.
3,500 per month.
3,400 per month, 200 GM.
200 GM. So that is to be calculated.
Your Lordship, there are there is an account balance. She can appropriate from that.
No,
and
the court has to pass an order.
Yes, your Lord.
Okay, let the report come then.
Lordship, I'm grateful.
"31, my lord, I appear for the plaintiff.
For the defendant in this matter.
Yes.
My lord,
Yes, what has happened in the appeal?
My lord, the appeal couldn't get heard, my lord. It's there on Monday.
Hmm.
Last 2 days, my lord, we waited. Mr. Mitra was also there. So with that.
So
I think the division bench may not be, this bench may not be sitting for the next 15 days on the whatever circuit. So it can be 3rd week of April.
Which one?
This matter.
No, it is not in the commercial.
No, in the ordinary division, but the bench is not there.
The
my lord.
division bench won't be there. Mrs. Sen may be going circuit also.
Same bench.
Same
Yes,
bench,
yes,
same
yes,
bench.
yes, same bench.
The commercial
Yes,
system-
yes, yes,
Yes,
yes.
my lord.
We have
Same
only
bench
one
taking
option. One, expecting too much. Two appeal court. Two appeal court. Why not? Same bench.
Good.
That also includes the appellate side.
Commercial matters and
matters
non-commercial
from
matters.
4 commercial districts, even non-commercial, all. After,
See the caliber of the Calcutta judges.
yes.
Like my lord, the appeal court is also equally busy.
So what do you want?
My lord,
Can be after
may it stand over, my lord.
third week of
April.
April.
Executrix, plaintiff.
Plaintiff, my lord.
Plaintiff number 1.
So appearing
Plaintiff
for the
number 1.
plaintiff number 2, and so appearing for the defendant. Counsel for the plaintiff number 1 submit that the appeal prepared by the plaintiff number 1 is still pending and prayed for adjournment. In view of the submission made by the counsel for the plaintiff number 1, the case is adjourned.
First week of
Let the
April.
matter appear
First week of April or any date.
on 25th of April 2020.
25th. 25th. Oblige.
My lord, I appear for the defendant.
Yes.
For the plaintiff, my lord.
My lord, I have a copy of my suggested issues ready. My lord,
On the last occasion, my lord directed to file the judge's brief of documents, my lord, a letter has been sent, my lord, to the defendant, my lord, to provide a compilation of the documents that has not been sent yet.
yes, my lord, we are preparing that. We shall be sent.
And my lord, we are also preparing our suggested issues, but we will file it on the next occasion.
Suggested is to prepare only 2 lines with this.
My lord, one small more, it's almost ready, my lord.
What? What are the issues? You are for the plaintiff. Whether the will is genuine or not, that's all.
Only one issue should be. At a copy there? नहीं? देखिए আমার জন্য একটা কপি দেন যতসব দেখছেন তো
Go through this, whether you record any further issue.
মেল করতে
What issue further required? Okay, come next week. So appearing
Lord,
for the
this
plaintiff,
here was
so appearing for the defendant. Counsel for the defendant has filed suggested issues. Full stop. Counsel for the plaintiff prays for time. Full stop. For the interest of justice, case adjourned. Let the matter appear on 21st March 2025 for framing of issues. In the meantime, the plaintiff is directed to file the judge's brief document.
I'm so grateful.
Next.
I am for the plaintiff. That is my application under Order 6, Rule 17. On the last occasion, my learned senior friend, Mr. Ghosh, has already been concluded his submission. And my learned friend will be start today.
My lord will kindly take the application seeking amendment in the affidavit of asset in the probate proceeding. Now, so far the amendments are concerned, my lord, I'll straight away, Lordship will kindly come to the proposed amendments. Proposed amendments are starting in the affidavit of asset. It is from page 14. Page 14 is the underlined portion. So for these underlined portions are concerned, my lord, I don't have any objection. But only thing, in page 17, this A, the property in A and B, these two properties which he wants to now include in the asset. Now, this is these two assets. Another property which is there at page 3. Page 3, it is not underlined, but he has made a reference. I'll tell you why I'm saying this. In page 3, he says with regard to, he has not underlined this, he says 60% of the partnership of Messrs. Kalipado Bag. In the first entry in page 3. Now, there was an arbitration in respect of this partnership firm after death of this gentleman between the daughters. The 5 daughters are fighting, 4 daughters. Now, I hold a award in my favor of 8.5 crores against them. Award has been put into execution before Commercial Court, Asansol. They have not furnished any security, so no 36. Award is being pushed in execution, no stay. In execution, receiver appointed over these two properties where today, which they want to bring in now in page 17. And in that, receiver is appointed to sell the properties. They have given consent to appropriate the money because 8.5 crores is against them. So these two properties, they have a share, all father's properties. So they are ready and willing to sell these two properties in execution. Receiver appointed, receiver has invited bids. Both parties have opened to get the bids. 5.5 crores bid has come in. So these are the process going in the Asansol court. These are all post filing of this suit, even post filing of my opposition. So those are not on record. Now today what they are doing, the object is you add these here and then you go and consent in the receiver and you frustrate the receiver and any buyer who comes in, you frustrate that. So if Lordship's pleasure, I have to bring on record these. Because these are subsequent events. A liberty be given to me to file a supplementary affidavit to bring on record the award, because in the meantime the award has award, the proceedings in Asansol court and the receiver's report and everything, because the order clearly records that these two properties, they have consented of selling. Receiver brought a buyer of 4.5 crores. They brought a buyer of 5.5 crores. So we can sell whoever the highest price. So now if these properties goes in this testamentary proceeding, it becomes, this is the way to stall the execution. So kindly grant me a liberty to file a supplementary affidavit to bring these on records.
But if we were given the consent in the execution proceeding for selling of the property, so how this property may be included in this affidavit of assets of the Appellate Matters?
In reply, taken up on one day, Mr. Ghosh is appearing in this matter, but he has not come today.
Who?
Mr. Amitabh Ghosh. On the last occasion, he argued this matter. Kindly taken up on Monday.
No.
Monday or Tuesday.
No, give me some time to file the.
You want to file the
supplementary? Yes, to bring on the subsequent events. The papers will come from Bankura. He's my advocate. He's my advocate.
So appearing for the plaintiff, so appearing for the defendant. Plaintiff has filed an application being GA1 of 2021, praying for amendment in the affidavit of assets. Full stop. Counsel for the defendant submits that at page, in the proposed amendment at page 17, serial number capital A and capital B are the properties which is the subject matter of the execution proceeding in the arbitration case pending before the London Commercial Court at Asansol. And as such, the plaintiff intend to bring on record certain documents by way of supplement. Defendant intend to bring certain documents in connection with the said property by way of supplementary affidavit and prays for time to file supplementary affidavit. Considering the above, the defendant is granted leave to file supplementary affidavit disclosing the documents in connection with the arbitration proceeding and arbitration proceeding as well as the execution. Disclosing the arbitration award as well as the execution proceeding in connection with the property as mentioned as appearing in page 7, proposed amendment at page 17, capital A and capital B, within a period of 1 week from date.
10 days, madam.
Within 10 days from date, after serving the copy to the learned counsel for the plaintiff, let the matter appear on 28th March 2020.
Already liberty may be given to if the supplement against the supplemented
List of the plaintiff is at liberty to file a reply, if any, to the supplementary affidavit within a week thereafter.
Obliged, madam.
Grateful.
What about the 3? Yes, GA3?
This is ours amendment.
It's my learned friends amendment application.
Not briefed. Okay. So we will come back on 28. 28.
My lord, I appear on behalf of the propounder. My lord, your lordship will find one application, GA application is there. My lord, a very small amendment.
GA3?
GA3. My lord, a very small amendment for incorporating the explanation on account of delay. My lord,
14A?
14, yes.
A to D?
Yes.
What do you want to? Delay filing the...
Just receive the petition, my lord.
My lord, it doesn't change the nature and character.
Change I don't have all the documents at the moment. It takes some time for replying the amendment petition.
My lord, absolutely, my lord, it is something, my lord, which I have to show, which I have to, my lord, satisfy the court.
See, he wanted to bring the amendment on and bring the some of the paragraphs disclose explaining the delay in filing the letters of administration. So that if it is allowed also, if it is allowed, you will get the chance to cross-examine the witness, test the witness whether the explanation is sufficient
or not.
What do you want?
I want something.
Well, my lord, the only difficulty which I am facing is, my lord, the executrix, I am told, my lord, is very aged.
What
In
is the
fact, my
age?
lord, after allowing this application, I might, my lord, come
I
up
am
before
fixing
your-
next week, eh?
2 weeks.
2 weeks?
My lord, she is already 80 years old.
Senior citizen, sorry.
80 years.
There is a burden upon this court, upon the senior citizen.
As on March 22. My lord, as on, she's now 82 years.
Come on 21st. So appearing for the plaintiff, so appearing for the defendant. The plaintiff has filed an application being GA3 of 2025 praying for amendment in the amendment of the probate application. Probate applicant / plaint person. Police counsel for the defendant prays for time. According case is adjourned, let the matter appear on 21st of March. Next.
My lord, I'm serving the application here and now. My lord, a copy has already been served, but still, my lord. My lord, let it.
The copy of the application is served upon the learned advocate for the learned advocate for the defendant in the open court. Yes.
Grateful.
Lordship, item 35, I beg to appear on behalf of the caveat or defendant. I have my suggested issues ready, Your Lordship.
I'll hand up my suggested issues. I appear for the plaintiff.
Framing of issues.
Yes.
You're for the plaintiff?
I'm for the plaintiff.
Whether the registered will.
One issue. There's that.
Quite a handful on my part, Your Lordship. I have at least 13 ones.
13 issues in a probate.
No, 13 issue. The first issue is the Kalidas.
It's Kalidas. He himself saying.
Yes. It's a compiled one, Your Lordship.
Issue may as a preliminary issue right now. Well, Lordship will frame only one issue. There is nothing else.
I'll leave it to your lordship.
So your 2 is covered on 1.
Yes.
Correct.
Yes.
4, 5,
1,
6,
2 also, 3 also covered with the data executed in terms of provision of section, and that is not required. There is any provision for execution of the will. It is the provision for prove the will.
Yes.
I don't know what they mean by unnatural will. When it's issue number
Manufacturer
12.
product document of fraud. Undue influence. Record. So and so appearing for the plaintiff. So and so appearing for the defendant. Both the parties have filed their suggested issues. Heard the learned counsel for the parties, peruse the pleading and the suggested issues. The following issues are framed. This 1, 2, this 3, this 4, 5, 6. So your issue, I am taking issue number 1, issue number 5, issue number 6, and issue number 8.
Grateful.
Evidence?
Yes, I'll have to prepare the judge's brief. Give us
The
10 days
plaintiff
time.
is directed to file the judge's brief document within 3 weeks after serving the copy to the learned counsel for the defendant. Evidence?
Yes,
List the matter, give the date. List the matter on 7th May at 3 p.m. for witness action.
Grateful, sir.
I'm grateful to your lordship.
Number 36.
In 36 minutes, I am appearing. Lordship kindly takes it up after 2-3 minutes. I am in the downstairs. I'll come up.
My lord, 36.
Till the time, my lord, we can address.
But just 2-3 minutes, I'll reach the courtroom.
Okay, you come. I
But
will
Mr.
this court
Dasgupta,
will
whom
wait.
are you representing?
Yes.
I am applicant in 2 PLA proceedings, and third one is my application for grant of probate.
Then, Lord, we shall
Okay,
address on his application.
We have to address on his application, my lord, because
What is the application for?
he has filed an application seeking
For citation, my lord. For
Citation.
citation, kindly give me 2 minutes. I am reaching in lordship's before your lordship in 2 minutes.
Okay.
Then
Aso.
grateful lordship.
Not pass over, my lord. Your lordship.
Application. He address first, no?
Question number 39.
9. Thank you, pilot. I'm filing the affidavit of documents.
Who is for the defendant? Inspection completed.
The direction, I will send notice for the discovery and inspection.
So how you file the affidavit document without the discovery and inspection?
Notice for discovery and inspection. Original will and the death certificate.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff has filed the affidavit of document. Let the same become the record. The parties are directed to complete the discovery and inspection of the document within 2 weeks. Full stop. Affidavit of admission and denial of the document will be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 11th April for framing of issues.
I'm on the behalf of the plaintiff.
For the defendant, my lord.
By an order dated 14th November 2024, your lordship has directed me to file judge's brief, affidavit of denial and admission and the suggested issue. So, my lord, today I'm filing it in the court, the judge's brief.
Inspection completed?
Yes, my lord. Yes.
Where is the framing in this issues?
My lord, I have not filed, my lord. I'll leave it to your lordship.
Okay.
I have total 4 issues, my lord.
Does the will duly executed and attested as per the provision of 63? Whether the testative of testamentary capacity, whether the signature of it. Where is your affidavit document? No. No document. You are not relying on any document.
No, my lord.
Sense suffering for the plaintiff, sense suffering for the defendant. Plaintiff has filed the judge's brief of document and affidavit in support of an affidavit of admission and denial of the document, as well as suggested issues. Let the same be kept with the record. The defendant submitted, they will not rely on any documents. Full stop. They are not relying any document.
No, my lord.
Considering the suggested after hearing the parties, after hearing the parties, considering the pleading and the suggested issues, the following issues are framed. 1, 2, 3, 4. Full stop. Full stop.
My lord, all issues, my lord. My lord.
Full stop. Evidence. Let the matter appear on. Give the date. 8th May. थर्सडे मत रखो. थर्सडे क्रिमिनल बाद में देखा जाएगा, हो रहेगा नहीं रहेगा. हाँ 13th में. 13th में तो नहीं रहेगा. 13th में तो चला जाएगा. 13th में सर्किट है ना, उससे पहले कोई डेट नहीं है. जून कब है? 7th April 3:45
My lord.
for witness action.
My
Bring the witness on that day. Yes, next.
Password can
Password 36.
Number 36.
36, I beg to appear for the plaintiff, my lord.
Lord, I am opposing the application.
And there's an application has been filed by Mr. Dashgupta's client, my lord, seeking for issuance of special citation in his name, my lord.
Let him move.
You are for the plaintiff.
I'm for the
You are
plaintiff,
for
my lord.
Mr. Alim.
I'm also for the plaintiff, my lord, in TS 25.
In all cases, you are for.
37.
You are appearing for.
Lord, I am the plaintiff in one, but not plaintiff yet.
TS
अच्छा तो वह अच्छा 24, 25 हो.
Yes,
My lord, my lord.
He wills of the same, allegedly of the same person. I am saying I am the one who has been assigned as an executor in one of the will, and that's the last will. They are also saying the same thing, except that in one of the proceedings there is no executor. It's a will without an execution. So they filed as a beneficiary for letter of grant of administration. Now, my lord, in other 2 matters, I have filed application, 2 applications also could find. For my lord, prayers are very innocuous. Since I am an interested party in those proceedings, and these 3 matters have not to be acted together with analogously, so I should get a chance to defend those proceedings. I'm not accordingly, I have asked for the citation to be issued on me.
No, just a minute. TS 24 of 2023. Who
My
is for
lord.
the plaintiff?
I am for the
You are
plaintiff.
for the plaintiff.
My
In
lord.
this, who is the defendant? You
I'm
are
the defendant.
You are the defendant. In that case, also there is a will.
Yes, my lord.
There is a will,
My lord.
and you are the executor.
I'm the
And
beneficiary, my lord.
There is no executor. in that.
Executor and beneficiary both.
No, there is no executor.
There is
in
no
that.
executor, my lord. I am the beneficiary,
Beneficiary.
my lord.
So actually, it was the letters of administration.
My lord.
Okay. And
Which
you
is
are
the-
for the defendant.
Yes, my lord. In the suit of TS 24.
24.
25, I am for the plaintiff.
I am on 24. So 24, you have filed an
I
application.
filed application.
You were connected with TS4.
Yes.
Yes, but I am. Yes, I have got TS4. Now that I am.
So
filed an
TS4, you
application.
are of the same property.
Yes.
You
No,
are-
properties are different. But in my will, the entire estate is covered.
Hmm.
In their wills, I am told that we are not, the entire estate is not covered. Only one property is common. But since one common property is included in my will as well,
Okay.
I am
So,
interested there.
so TS4 of 2024, you are the executor.
Yes, sir. I am
You are the
executor.
executor.
Yes, I am the
And they are the defendant.
They are both of them are different.
Both are the defendant. Now you are telling that as all the suits are clapped together, so you have to be given a notice in 24 and 25.
Notice, I am a notice for the purpose of filing caveat and affidavit in support of caveat. So that I can
Correct.
join
That
as
is the
defendant.
that is the thing. Yes.
Yes, my lord. Lord, I appear for the plaintiff in TS number 25. In that matter, my lord, my learned friend is the defendant. There is an application.
No, that's why. What is your objection regarding?
Yes.
My lord,
First, let him
first
say
of all,
that.
my lord, he does not have any caveatable interest, my lord, in this
No,
matter.
but the problem is that
My lord.
there is another suit.
My lord. My
There
lord.
is a will.
My lord.
In
My lord.
that will, other properties are also mentioned.
My lord.
And in that will, the testator or testatrix who are maybe the same. Correct. Property of all the three suits of the one testatrix.
My lord.
And one testatrix is having three wills. So in one will, both are exchanging. In another, you are telling that you are not, in the other two wills, you are telling that he is not having caveatable interest.
My lord.
In that property only. So in that, in your TS24,
my lord,
what is the property?
My lord, in question, the whole estate is in question.
So if it is whole estate, that is covered under TS4.
Yes.
That is covered under TS4.
My lord, I bow down what my lord is saying, my lord. But the fact is that, my lord, TS24, they are aware of TS20 for a very long time. For now at this moment, after such a long time, they have come up and with this plea that they needs to be added as a party in that proceeding as well.
May I submit, my lord? I also.
So you are on delay point.
I am on the delay point as well as, my lord. My point is also that we have filed our objection with regards to his suit, my lord, and we have he was aware of the fact that we have also in that affidavit in support of caveat, my lord, we have also stated about our suit and everything. He could have come up a long back. Now
he has entered into.
My main point is, my lord, that only that he is filing all this application in order to clutter this whole proceeding so that no proper adjudication happens.
That's why I'm asking. If you want the expedite of the matter, nothing else. I will pass an order, issue notice. He will file immediately the caveat as well as fixing a time so the matter can be expedited. If you wanted to contest, no problem. You file affidavit in opposition.
Well, then let me kindly grant me a opportunity to file an opposition.
You're going to oppose this?
I'm oppose his application.
No, by filing an affidavit in opposition. Yeah. Now, my learned friend should not at least say delay in proceedings. Your lordship may
I'm
kindly sees
seeking
the
for a
last
very
order.
short time, my lord. 1 week maximum.
Your lordship may kindly sees the last order. My lord, today was for framing of issues. Now, my lord, if I'm not wrong, my lord, my learned friend is the second advocate, the changed advocate, my lord. Previously, my lord, one Kane Jana was there, my lord. We had served the affidavit in support of caveat, wherein we had mentioned that, my lord, there is a PLA filed by us. That was in December 2023. Today we are in March 2025.
You want to file affidavit to the
No, I don't wish to file affidavit, my lord. It can be heard. Your lordship may kindly hears it. Lord, if it's get allowed, it's get allowed. Lord, we can
My lord,
contest it here.
I want to oppose his application.
No,
oppose. Will you want to file an
want to file affidavit? Then I will direction. If you not file, I will
My
hear.
lord, my instruction is to file an affidavit, my lord.
Then, Lord, we will also.
You will not file.
Then we will also file. What to do? He is filing. I thought we will argue here and now.
If you lordship allows, kindly adjourn the other two proceedings, at the same way.
No, that I will pass a decree.
Because I have.
You go. Then you file an.
Your lordship kindly sees, my lord, last order, my lord. Kindly sees the last order.
Correct, but problem is that now they, as per this, all the is to be clubbed. One has filed an application that is to be adjudicated. That's why I am asking both of you if you wanted to expedite, because whatever it is, there is a will.
Let them file Let them file. Let us file. Let him.
Because ultimately there is a three will, and with all the will is to be adjudicated.
Lord,
instruction opposition.
Lord.
Okay. So suffering for the plaintiff in TS 24 of 2023 and so appearing for the defendant in TS 23 of 24 of 2023. So appearing for the plaintiff in TS 25 of 2023, and so appearing for the defendant in TS 25 of 2023. So appearing for the plaintiff in TS 4 of 2024, and so appearing for the defendants in TS 4 of 2024. The plaintiff in TS 4 of 2024 has filed two applications. Two applications being, where is the GA?
GA1
GA1 of 2025 in TS 24 of 2023 and TS 25 of 2023. Praying for
various reliefs are primarily for citation. Most of these are without consequential relief.
praying for
Prayer for condonation.
Condonation of what? Citation has not been issued.
praying for grant of leave to file
If it is in support of the
file affidavit in support of master summons.
let's see, that's the primary plan.
Special citation be issued. At your
Lord, I was on that, but
here are the basic prayers. C and E, press lordship and
praying for leave to file, affidavit in support caveat as well as affidavit in support of caveat.
Simplicity, that is the
Please stop. Counsel for the plaintiff in TS 24 of 2023 and 25 of 2025. 25 2020?
23. Both the suits are 23.
2023. Press for time to file affidavit in opposition. Let affidavit in opposition be filed within a week. Reply, if any, there to be filed within a week thereafter. List the matter on 28th of March 2025 for hearing of both interlocutory application filed by the plaintiff in TS 4 of 2020.
Lord, by your lordship.
Okay.
And Lord, just one more indulgence.
ठीक है TS 24 में J1 TS 25 में J2 कर दें ठीक है J1 J2.
Lord, just one more indulgence, my lord. Lord, let it be understood between us, my lord. In the event the application is allowed, my lord, he should come up with his suggested issues because we have filed our suggested
Yes, my
issues.
lord. In both the suits, my
fix it.
Yes, both
That's why I indicated that you are not.
I am, Lord, I am agreeable.
No, my instruction is otherwise, my lord.
Carrying, I thought lordship would, because these are generally applications are allowed. So
No, not generally. I will oppose.
Okay. Yes, next. Okay,
Grateful, Lord.
time हो गया.
My lord, in this item number 59, my lord, very short application is there. 59, my lord, item number 59, very short application only for one property outside, my lord. So
The
my
court is having short period of lunch.
lord,
subway matter.
Yes.
My lord, I had preferred a 5 and 8 application. My lord, allows me to place the 5 and 8 application. My lord, this is the affidavit in reply, which may be kept on record. We have already served it upon them. My lord, before I enter into it, let me allow me to give a short recap. My lord, there were two non-binding offers that had been given. They were non-binding indicative offers of two premises of Subway, which are franchisees. Now, these two franchises were in one of them. At the 5 and 8 is with relation to one of such offers. Now, based on a joint offer, subsequently, two separate franchises were dealt with, and thereafter one of them had been completed. This is their pleadings, I'm saying. And with regard to the second one, the difficulty that was faced was with regard to the condition precedents. Condition precedents required that this had to be completed within a particular period. We are saying that it had far exceeded. They are saying no, they are trying to interpret it in a different way. Now, that apart, we are saying that the BTA that was entered upon, they have signed the document and handed it over to us. And this BTA, which was consequent to the non-binding indicative offer, where 75 lakhs were supposed to be paid, and the premise was they were holding it under a license, a lease or license, my lord. They were supposed to, the BTA condition precedent, they were supposed to transfer it to us. Now, the difficulty that was faced from our side was that this particular premises was already a leased premises. These are Salt Lake premises. Now, leased premises, that apart, there were 2 or 3 different parts. Like, for example, the lease was in the name of Arun. He was giving the lease Arun, HUF, etc., 3 different parts, which was not acceptable to us. And it fell out. We terminated that BTA. That apart, the franchise, with regard to the franchisee agreement, we gave them a pre-termination notice for the basic reason was every 7 years they had to remodel. That remodeling had not been done. They are saying that this remodeling ought to be done by us because of the BTA, which we are saying BTA is terminated. Once terminated, there is no question of that. My lord, at that point of time, had given a direction of stay of the pre-termination notice. This is the background of the case, my lord. Now, my lord will kindly come to my 5 and 8 application.
GA2.
GA2, my lord. Page 46, my lord. BTA starts from page 32. My lord will kindly see 14, page 46. Particularly 14.3, my lord.
BTA start 32.
BTA starts from 32.
Yes.
And the arbitration agreement
46.
Clause is 46. May I place 14.3. Any dispute which is not resolved within 30 business days after the service of a dispute notice, whether or not a dispute meeting has been held, shall at the request of either party be referred to arbitration in accordance with the arbitration rules of the Singapore International Arbitration Center for the time being in force, which rules are deemed to be incorporated by reference in this clause. The number of arbitrators shall be 1, who shall be appointed mutually by the parties. The language to be used in the proceeding shall be English. The seat and the venue of the arbitration shall be New Delhi. So now, my lord, will kindly come to page 160.
Yes.
So this is the initiation of arbitration, which we have referred, my lord. My lord will kindly see page 161, where we have referred to the BTA. And my lord will kindly also see page 162, serial number 4, where we have, may I place serial number 4? It is submitted that the business transfer agreement dated 6/12/23 was terminated by Eversub via email dated 28/5/24. Pursuant to such termination, disputes have arisen between the parties, arising out of and relating to the business transfer agreement dated 6/12/23, which is this agreement, my lord.
Yes.
The dispute between the parties are enumerated herein below. Whether the termination by Eversub of business transfer agreement dated so and so in respect of store number is bad in law and liable to be set aside. Whether business transfer agreement in respect of store number so and so is valid and binding. Whether the business transfer agreement in respect of store number so and so has been validly terminated. Whether the business transfer agreement in respect of store number so and so is specifically enforceable or liable to be specifically performed. Whether the business transfer agreement dated 6/12 in respect of store so and so is capable of being performed. Whether the business transfer agreement dated 6/12/23 in respect of store number so and so is a void agreement. And whether Eversub is liable to pay consideration of rupees 75 lakhs to Mrs. Anjudas. This is the dispute that we have. Now, my lord will kindly come to the their opposition. But with regard to my 5 and 8 application, they have given an opposition where the relevant part of their opposition is paragraph 6 and 7. Now that allows me to place paragraph 6 and 7.
Yes.
My lord, may I please? With reference to paragraph 5 to 7 of the said application, save what appears from the record and save has been specifically admitted by me herein, I deny all allegations that are contrary thereto and inconsistent therewith. Said business transfer agreement dated 6 December 23, though signed by me, my lord kindly notes this, though signed by me, has not been signed on behalf of the defendant number 1, applicant, and this would be evident from the copy of the said business transfer agreement dated 6 December 23, annexed to the said application. Now, my lord will also recall the prayers are that prayer C is that he is seeking specific performance of this business transfer agreement.
Correct.
He has signed this agreement. I say that 1996 Act makes it clear that an arbitration clause contained in any document or agreement is not valid unless the said agreement is signed by the parties thereto. As such, the arbitration clause contained in the said business transfer agreement dated 6 December is not valid and of no effect. So on the one hand, he is saying that he wants to rely on this specific performance of this, and he is himself saying that this agreement is not valid at all. So there is a blowing hot and cold. With regard to his application, it is applicable, specific performance. And with regard to 5(8), since it is not signed, it is.
What is the prayer in the main suit?
I'll come to that. Main suit to the plain to the. My lord will kindly come to my application. It is at page. I've set out the prayers, which is at page 4, paragraph 4.
Declaration that the termination of business transfer agreement in respect of different number 1 and 4.
So he says declaration that the termination of business transfer agreement in respect of so and so by the defendant number 124 is bad in law and is liable to be set aside. One. Next, my lord, the declaration that the business transfer agreement dated 6 December in respect of store 57 is valid and binding. So there he says it is not valid. Here he seeks a declaration that it is valid and binding. Now, my lord, you kindly see C, which is also very important.
Yes, yes.
C. C is declaration that the pre-termination notice dated 15th April 2024 is bad and is liable to be set aside. And then D, a decree for specific performance of the said business transfer agreement dated so and so for transfer of the store 57767 for a sum of 75 lakhs by the defendant number 1. So in one place he is saying valid, there should be a specific performance based on that. And 5.8 he is saying is not valid because it's not signed by me. Now I have through actions.
Who is having the agreement?
Agreement is with me.
You are having the original?
Yes, my lord.
Signed by parties?
No. At that point of time, I have to be candid. I have not signed. My signature is not there. But I have acted upon them. Based on that, there are emails to that extent I have annexed to this application. And that apart, I have also placed this before the arbitration institution also. There also is, I have not done anything which is illegal later on. It's not that I have put my signature after that. I could have, my lord, if my lord, since the document is with me, I could have. I didn't do that. Through my action, I have terminated it. The minute I have terminated it, I have accepted that this agreement is there, which is why I have terminated it. So there is no question of non-validity of this aspect. So my lord will kindly come back to the opposition once again.
Yes.
Again from I say that 1996 Act makes it clear that an arbitration clause contained in any document or agreement is not valid unless the said agreement is signed by the parties thereto. As such, the arbitration clause contained in the said business transfer agreement is not valid and of no effect. Since the said arbitration clause is not valid, I deny that the disputes relating to the said agreement dated 6 December 23 between the parties are liable to be referred to arbitration in terms of the alleged arbitration clause. The said business transfer agreement dated 6 December is a written document, but the same has not been signed by the defendant number 1 applicant. In this case, document has been sent to him, he has signed and sent it back to me. I have acted upon that on that basis. He says, now you have not, since you have not signed, there is not valid. It is denied that I have misled this honorable court as alleged or that no submissions were made on my behalf with regard to the said arbitration clause. With regard to the relief of the plaintiff, I say that the same is my lord. And my lord will kindly see paragraph 7. These are two material paragraphs in the opposition. My lord, I'll read from the 4th line. I say that though the defendant number 1 applicant has purportedly invoked the arbitration clause allegedly contained in the business transfer agreement dated 6 December, the said arbitration clause is not a valid arbitration clause, and I have suitably responded to such invocation. Copies of the emails dated 2nd September, 12th September, 24th September 24 exchanged by or on behalf of the parties are annexed hereto and collectively marked with the letter A. I say that in the present case, the disputes between the parties herein, which are subject matter of suit, cannot be referred to arbitration since the defendant number 1 applicant has not signed the said business transfer agreement.
The contention is there is no signature of the defendant.
Yes, that's the only contention. Now, my lord, that apart, there is nothing else. My lord allows me to place 2 judgments, my lord. My respectful submission is that I have acted upon that. I have terminated upon after acting upon that. Once that is done, I say that the agreement was complete. He says that it is valid in his prayer. He seeks a declaration of validity of that agreement. And I say after considering that, I have terminated it, which is why it is arbitrable. My lord will kindly My lord, I specifically refer to paragraph 6, 7, and 8, particularly 7 and 8, my lord.
Yes.
My lord, paragraph 7, I'll start from. A perusal of the same shows that the respondent has expressly agreed to be bound by the arbitration clause, despite the fact that it is a printed condition annexed to the bill of lading. Secondly, it must be remembered that the respondent has itself relied upon the bill of lading as part of its cause of action to recover the sum of 26,53,593 in the suit filed by it. The respondent therefore cannot blow hot and cold and argue that for the purpose of its suit, it will rely upon the bill of lading, though unsigned, but for the purpose of arbitration, the requirement of the Arbitration Act is that the arbitration clause should be signed. In addition, we may indicate that the law in this regard in Jugal Kishore Rameshwar Das versus Gul by Hormuzji is that an arbitration agreement needs to be in writing, though it need not be signed. The fact that the arbitration agreement shall be in writing is contained in 1996 Act, Section 7, subsection 3 thereof, Section 7, subsection 4, only further adds that an arbitration agreement would be found in the circumstances mentioned in the 3 subclauses that make up Section 7, subsection 4. This does not mean that in all cases an arbitration agreement needs to be signed. The only prerequisite that it be in writing, as has been pointed out in Section 7, subsection 3.
Yes.
So in this case, my lord, arbitration is in writing, arbitration agreement, the BTA is in writing, arbitration agreement is a part of that BTA which is in writing, which he has signed and given it to me. I have acted upon it and thereafter I have terminated it. And these paragraphs clearly, I rely on these paragraphs. My lord, with regard, there is another judgment that I want to refer to, my lord. Look, paragraph 188.7.
One
188.7 onwards.
Yes.
Well, may I place 188.7? The arbitration agreement may also be in writing if it is contained in the record of the agreement comprising exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means. So I have acted upon through electronic means, through Gmail, through emails. I have been communicating about this BT agreement and me acting upon it. In these instances, parties to the agreement as well as the existence of the arbitration agreement is a matter of interpretation and construction by the referral court or the arbitral tribunal. The inquiry under Section 7, subsection 4, subsection 4b is to determine whether there exists an agreement for referring the matter to arbitration and who are the parties to such an agreement. The referral court or the arbitral tribunal, while considering the claim of a non-signatory for reference or the objection of a non-signatory to the inclusion in an arbitration, will primarily examine the record of agreement under Section 7(4)(b) and consider the express language employed by the parties. Once the express terms are ascertained, their meaning is a matter of construction by the court or the arbitral tribunal. The object of such construction is to discover the intention of the parties. Intention must always be ascertained through the words actually used, for there is no intention independent of the language employed by the parties. My lord, I rely on these. My lord, kindly sees now the act.
Give the arbitration. Yes.
Lord, Section 7.
Yes.
Arbitration agreement.
Yes.
1. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. 2. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. 3. An arbitration agreement shall be in writing. 4. An arbitration agreement is in writing if it is contained in a document signed by the parties. Now, B is what I rely on. An exchange of letters, telex, telegrams, other means of telecommunication, including communication through electronic means, which provide a record of the agreement.
Yes.
So I squarely fall within this provision, my lord.
Yes.
And my lord will kindly now again come back to my agreement, to my application. When emails, the emails. What are the emails? The termination and then all that.
That is GA1.
My lord will kindly take the GA1 once.
Yes.
GA1 page, the second volume, page 193.
One 193.
193. This is the termination of the BTA.
Yes.
Communications we have acted upon. My lord, kindly may I place this? As you are aware, this is being written by one of the respondents here on behalf of the Subway, the defendant number 1. As you are aware, we had entered into a business transfer agreement dated 6 December 2023 in relation to a proposed acquisition of your business being operated in the name and style of Subway as a going concern by way of a business transfer. So there's a clear that
Yes.
entered into a business transfer agreement.
Yes.
Under the terms of the BTA, the parties had agreed to consummate the proposed transaction upon the satisfactory completion of agreed conditions precedent. The proposed transaction contemplated in the BTA was commercial in nature, and its material and key components, including proposed consideration, were predicated on underlying data and information in relation to the business undertaking underlying data as at the time of execution of the BTA. The parties understood the time sensitivity of completing the transaction, since underlying data as on the execution day of BTA would not truly reflect the affairs of the business undertaking for the future period. Given the above, the parties wished to complete the transaction at the earliest, and in furtherance of the same, had explicitly agreed long stop date of 26 December 23. So, my lord, this email is being written on 28 May 24.
Correct.
Based on the BTA agreement, the long stop date was 26 December 23. In the BTA, which was the last date for completion of the CP and closing of CP's condition precedents and closing of the proposed transaction, failing which the BTA was liable to be terminated without any liability to either party. As of this date, we note that the condition precedents were not completed by the long stop date and have not been completed to this day. So till May, they had not been completed. Therefore, the BTA stands terminated by virtue of expiry of the long stop date. Now, he will say, I should read the next portion also, which is relevant. Regardless, so after terminating that BTA, my lord, upon fresh, after termination of that BTA, they write, upon fresh consideration, they are saying, regardless, we wish to pursue the proposed transaction and discuss the same with you in good faith. As you will appreciate, as there has been substantial time gap between the time of signing the now elapsed BTA and this day,
We have now considered the underlying data.
in relation to the business undertaking as of the current date. And thereafter, my lord, thereafter, they have given a separate NBIU. Consequent to termination of this, they have, upon fresh considerations, given a separate NBIU, which they have thereafter not acted upon that separate NBIU. In the separate NBIU, which is a non-binding indicative offer, prices have reduced and some different conditions have been specified. But no BTA has been entered into thereafter, because they say that this BTA is valid and this termination is illegal. Now, whether this termination is illegal or not, that is arbitrary. And that
Prior to this, their termination, is there any communication with regard to the BTA?
Yes, my lord. Yes, my lord.
Referring the parties, between the parties?
Where?
You want termination.
No, prior to termination, any communication. The
Communication with regard to
yeah,
the
lots of communications, my lord. My lord will kindly see.
Reply that we have filed just.
Kindly sees our reply to this GA2, my lord. This is.
Yes.
Just 1 second, my lord. This is dated. This is the termination. My lord, will kindly see November 24, page 12. They have sent us the signed BTA. No, we have my lord, this is the attached BTA that we had sent
provided to sign copies.
Yes. Thereafter, my lord, we kindly see. They have respected. No, there are other emails that were there. Are emails
After December.
Yes, after December, between December to May. Well, the emails are there, but they have not been annexed here. There are numerous emails to that effect. Do we have it in hand?
Page 14.
My lord.
Page 14 of the AIR.
My lord.
PFA, the BTA signed and scanned copy by Anjudas. Page 14 of the.
Yes, my lord. Yes, my lord.
Please note the schedule, the list of the differs from the LCHEC.
Yeah.
And
the Excel sheets back for. Thereafter also there have been numerous communications that were there. Post December also there have been communication, and it fell apart.
Yes.
In fact, there are emails to that extent where they have annexed in their petition, in their GA1, where they have sent the lease documents, etc., of the landlord, which are there. My lord, may kindly take the opposition to their application, to GA1. No, my lord, Child and J, are there any communications? There are lots of communications are there, my lord. My lord, kindly come to page 79. Before that also, in fact, they have annexed those communications to show that this is valid.
Yes.
Page 79. This is December 21.
Page 79.
Page 79 of the affidavit, my affidavit in opposition.
Affidavit in opposition.
My affidavit.
Of the GA1.
GA1.
Lease deed draft EIPL. No, that is something.
My lord, will kindly see. My lord, kindly see page 79. This is from us, from one of our
No, 79 something difference here, different here. That is only one line. Mail is there, but only one line.
No, this is that
This one.
license agreement.
Only one line.
Is it this one? Eta konta? Which one is this? Next page. My pagination is wrong. At page 80. Huh?
Yes.
This is communications that were there. Thank you for giving your valuable time. On the basis of my telephone, they are writing this. On the basis of my telephonic discussion and brief facts I shared with you, request to please find attached the copy of the license agreement to be signed by and between Mr. Arun Kumar Maheshwari and Mr. Arun Kumar Maheshwari HUA, which is proposed to be registered in the concerned sub-register office. This is one communication. Thereafter, my lord sees Ritvik Das has written to Anju Das. Further, next page. Further to our discussion yesterday, we had connected with the lawyer suggested by you to seek his blessing on the draft prepared by Mr. Maheshwari. Kindly.
This is with regard to the agreement, lease agreement.
No.
We are
Acting upon the BTA.
by trying to sign the lease agreement.
Trying to culminate the BTA conditions.
Okay.
Post BTA, the conditions that we were acting upon. What I am trying to show is we were acting upon that. And then the next page, my lord's page 82. These are all emails with again Ritik, dear sir, this will be notarized at first and will be registered later once we are able to get so appointment at the registrar's office. Below that, thanks for the draft. I will forward it ASAP. Just a point of now, this draft that they are talking about is not the draft of the agreement. The draft of the license agreement between the landlord and that is what is being negotiated.
That's why I'm asking.
My lord.
This is with regard to the negotiation between the landlord.
Ultimately, it failed. Ultimately, it was not acceptable to Subway the contours of the license agreement that they wanted to do, which is why it failed. That was one of the main chief cause of the termination of the agreement, which I placed before my lord, the termination letter. And with regard to 5 and 8 application, those are then my respectful submissions. My lord, if my lord is with me, then I probably will not have to go into the merits. And if my lord is not with me, then will give me an opportunity.
Yes.
I would trouble your lordship with that to kindly take up the interim order that was passed on 2nd of July 2025.
You auto with auto guy.
My lord is to take paragraph 14 at page 7 of your lordship's order. This is the issue. Heard the learned counsel for the plaintiff produce the materials on record. The defendant number 4, that is my learned friend's client, was ready and willing to purchase both the stores for a total sum of 85 lakhs, out of which it should be 75 lakhs for store such and such and 10 lakhs for store such and such. The defendant number 1 has taken over store number such and such by paying only a sum of rupees 741,357 after deducting royalties and other charges payable, leaving the balance at 82,387 for store number such and such. But till date, the balance amount has not been paid. As regards store number 57767, neither the defendants have come forward to take over the store nor have paid the agreed amount. The plaintiff has also negotiated with the owner of the property for execution of the agreement, but the defendants failed to come forward for execution of the agreement where store number such and such was mentioned. Instead of making payment, the defendant number 4 has revised the sale price from 75 lakhs to 34 lakhs. It should be reduced or reversed. And on the other hand, the notice of pre-termination is issued on the basis of the alleged report of the defendant number 3. Then considering the facts, Your Lordship. So, Millet, this is the crux. My learned friend's client's application under 5 and 8 is on the ground that there is an arbitration agreement embedded in the in the business transfer agreement. And that arbitration clause says any dispute arising under this agreement would be governed by arbitration. Well, the first question which I ask myself is, where is the agreement? Disputes arising under an agreement. An agreement has to be in being for the purpose of compelling the parties, the contours, to compel the parties to stick to the terms and conditions. Admittedly, my learned friend says that he has not signed. Now, if it is not signed, so far as the agreement is concerned, that has not come into. So, if the agreement has not come into being, what will the arbitrator decide on the basis of which agreement?
So what is the prayer in the plaint?
For specific performance of the agreement. By specific performance of the agreement, I mean that you sign the dotted lines and take over my store at 85 lakhs or 75 lakhs.
Declaration, the termination of the business transfer agreement.
Yes.
BTA. Kindly come to the prayer portion of your application, page 4, paragraph 4.
Of GA1.
GA2.
I'm sorry. Yes. Declaration that the termination of business transfer agreement in respect of phone number such and such, dated such and such, where the defendant of board is and liable to be set aside. Declaration that the business transfer agreement is taken in respect of such and such is valid and binding.
Correct.
Declaration that the pre-termination notice such and such is bad and is liable to be set aside. A decree for specific performance of the business transfer
agreement.
Yes. So, my lord, I am asking him to enter into an agreement with me.
You have filed the suit on the basis of the declaration, on the basis of the business transfer agreement entered between you and the defendant.
He has given me a business transfer agreement,
Correct,
which is below a proposal that I agree to purchase your store at a sum of rupees X.
correct.
I accept that and I sign.
You signed it and send back to
And
them.
send it back.
Correct.
He doesn't sign it thereafter and say that the agreement has come into being. He gives me a counter proposal.
No, but after that, on the basis of the business transfer agreement, you both have negotiated.
Yes.
Both have negotiated, so acted upon.
Below, negotiation will always precede an agreement. Negotiation will not after. If there is negotiation after the agreement, then obviously the terms have not been agreed upon. I am on a very simple point. An agreement is consensus ad idem, not on principle on all terms. He may say that on principle he agreed to purchase, and on principle I agreed to sell. Terms and conditions have not been signed, the dotted lines have not been signed. So, bereft of that BTA, which is a document which is unsigned, there is no agreement in the eye of law today. Because there has to be an offer and acceptance.
Then why you are asking for the declaration?
Because of
the termination is illegal and void.
The declaration why I am asking is because thereafter, if your lordship sees, the termination letter says that since nothing was done due to the delay, my learned friend placed that, since nothing was done, as of this date, we note that the CPs were not completed by the long stop date
Correct.
and have not been completed to this day. Therefore, the BTA stands terminated by expiry of long stop gap.
So unless there is an agreement, unless there is an BTA, how it will be terminated?
No, what is happening is, Milord, what by meaning termination of BTA, the nomenclature of the agreement is business transfer agreement. Nomenclature, that's the name given.
Correct.
Which the parties are referring to as the BTA.
BTA.
That does not mean that there is that BTA agreement. If it is named as an agreement, it has to be signed and accepted by both the parties. My learned friend is referring to the nomenclature, that agreement for the transfer of business, which says that if nothing is done within the long stop gap, this agreement will automatically come to an end. The reason why I am seeking a declaration is, my lord, I am trying to say that so far as the expiry of the long stop gap is concerned, that will not prevent to automatically put an end to the proposal that you have made. I am asking him to sign. I am asking him to complete the agreement. It is not that my learned friend is coming and saying that you complete the agreement or you pay. There is no agreement to start with. That's the reason I am asking for specific performance. Because what is happening is this, my lord. If your lordship sees, my learned friend has not shown your lordship, my lord, that paragraph, that page number. Yes, Millard, yeah, GA2 Millard, page 94 is the subject. And kindly come to 156. And my learned friend is not denying it either. 156. Is it legible in your lordship's copy? 156.
156 only 2 line.
Yes. Kindly see.
Signed then delivered within the named founder.
So I have signed it.
Correct.
He has not signed it. Yes. So therefore, if he has not signed it, my lord, he cannot say, if today, my lord, he says before your lordship that yes, this is a binding agreement, then my lord, I get a decree on admission today. But he is not saying so. Page 154.
Yes, legible copy.
Yes. So far as he is concerned, he is not signed it. So, my lord, all I am trying to say is that the clause which my learned friend is referring to, arbitration clause, which is, I believe, my lord, is at first series.
Page 46.
That's very well. This has been complied with.
Page 46.
Yes. Governing law and dispute. This agreement. So this agreement, once signed, would make it binding on the parties. And thereafter, my learned friend would be within his rights to say that go to arbitration. But, my lord, on the other hand, not only has he not signed, today, my lord, he is not even abiding by this. So where, if I may ask myself this question, where is this agreement come? So the arbitrator is to decide a dispute arising out of this BTA. So the first question, my lord, that will fall for consideration, that was there an agreement? There is no concluded agreement between the parties because the dotted lines were not signed for whatever reason. I am asking him, he is not agreeing to.
So if there is no agreement,
yes,
if you are telling that that is no agreement, so automatically the termination is not binding upon you.
No.
If you are telling that the BTA is not signed by the party, so it is not an agreement. If it is not an agreement, if it is not an agreement, if it is not an agreement, so why you are asking for the declaration that the termination is wrong? So if there is no agreement, there is no termination.
Because of the reason, Millard, he is now trying to go back on the offer. And I am trying to hold him to that offer.
Correct.
So if I am trying to hold, and it's not that he is trying to go back on the offer for any other reason. Just because he has, within the time, not paid up. And thereafter, Millard, taking advantage of his own latches, he is saying that no, the time to complete the agreement has gone. I am saying that so far as this BTA agreement is concerned, which you have not signed within the long term gap, time was not the essence of it. You can even sign it today. So that's the reason, Millard, why I say that it has not been terminated. The offer still stands. You are only to accept and make payment. What is troubling your lordship is, Millard, even if I not asked for declaration, Even specific performance, this declaration would be inbuilt in that. Your lordship would automatically have to come to the conclusion that there is, my lord, an offer which was wrongly rescinded, parties had altered their position, and therefore I compel him to pay up this amount. So therefore, my lord, if he doesn't sign,
So pay up this amount in continuation of the BTA.
in terms of the BTA,
Correct.
then, my lord, your
In terms
lordship.
of the BTA.
So therefore, my lord, if he doesn't sign, suppose, my lord, let's take a very simple example. I agree to enter into, or I have entered into an agreement for sale, and thereafter I refuse to convey the property. Once I refuse to convey the property, the conveyance is a offshoot of that agreement, which is an. So therefore, but the terms of the agreement for sale is not that of the conveyance. Agreement for sale is I have agreed to buy, you are agreeing to purchase. Subject to making out a marketable title, I will convey the property.
Correct.
This is the background. So on principle, A and B agree to sell a property. Now thereafter, for whatever reason, that agreement fails. I file a suit for specific performance of conveyance. In that, what I am asking the court? I am asking the court that, look, there was an agreement. In that agreement, he has not performed his obligations. He is obliged to perform his obligations. And therefore, direct him to sign.
Correct.
Failing which, the registrar will sign on his behalf.
Correct.
Here also the same thing. I have performed my obligations. He is refusing to perform the obligations. I am wanting him to sign so that the agreement comes into being.
Yes.
So once he signs, or once your lordship feels that this is an agreement where I am entitled, my client is entitled to specific performance, then lordship will have to pass a decree saying that yes, you had offered, your refusal to withdraw from the offer after the defendant has already taken steps to transfer the property is wrongful. You have no reasonable ground to come out of it. Therefore, I am asking you to specifically perform. Then the agreement will come. Which, my lord, I am now taking the assistance of the court to have it performed.
So now kindly come to the prayer B of your plaint. Prayer D. A decree for specific performance of BTA dated 6th December for transfer of the store. What is the condition in the BTA with regard to the transfer?
The transfer of the
Where is the condition in the BTA?
Kindly take any one of them.
Yeah.
Your lordship is looking at GA1 or GA2?
GA2.
If your lordship is wanting the conditions precedent, that is at schedule 3.
Page?
It's 62.
Yes.
Inspection.
Termination.
Termination of franchisee. So the parent franchise agreement will come to an end. Then the premises has to be transferred. 3. Then 4 is license. This termination of existing agreements. License is notice from acquirer of food supplies license. Consent. Transfer in the founder shall have procured all consents required any persons for committing the completed so and so. Release of encumbrances. No due certificate from vendors. Then space left blank intentionally. Conditions precedent fulfillment certificate. The certificate has to be signed. So, beloved, this is what interim management is also there.
No,
So, part by part, these things.
No.
Now,
The prayer D is the specific performance of BTA for transfer of the store. Where is under which condition this prayer covered? This prayer is covered under the BTA. Under which?
I think, beloved, lordship is probably.
Because you are asking for a decree of specific performance for transfer of the shop store.
kindly comes to page 36 or 35. And whereas, has Rashi got it? And whereas the transferor is engaged in the business of running food and beverage outlets at the premises, that is the plaintiff. The 35. The transferor desires to sell, assign, transfer, convey, and deliver to the acquirer, and the acquirer desires to purchase and acquire from the transfer the business undertaking as defined hereunder, or a going concern on slum sale basis as defined in Chapter so upon the terms and subject to the conditions set forth in this agreement.
Correct.
Then, what is the terms? Purchase and sale definitions your lordship will for the time being give. On the closing date and upon the terms and subject to the conditions of this agreement, the transferor shall and the founder shall cause the transferor to sell, assign, transfer, convey all the transferor's right, title, and interest in and or pertaining to the business undertaking, free and clear of all encumbrances as a going concern, and on slum sale basis to the acquirer. And the acquirer shall purchase and acquire the transferor as a going concern on a slum sale basis all of the transferor's right, title, and interest in and or pertaining to the business undertaking, free and clear from all encumbrances. Business under the transferor shall construe to have sold and transferred, and the acquirer shall have construed to have purchased and acquired from the transferor the following with immediate effect from the closing date. All tangible licenses, these are below. For avoidance of doubt, it is clarified. Then consideration. The consideration shall be determined and paid in the following manner. The initial consideration shall be 72 lakhs. Closing consideration shall be determined on the closing date as follows. Closing consideration is initial consideration minus liabilities set out in Schedule 9, EPIL liabilities, adjustments for fixed assets which are not in premises, are not in working condition pursuant to inspection of assets. The acquirer shall pay the transferor 90% of the closing consideration, including set out and such. Within 45 days from the closing date, the transferor shall and founder shall ensure that the transferor shall assist the acquired as instructed by the acquired in the following. In transfer assignment of licenses, in making applications for procuring fresh licenses, in procuring in principal approval. So, these are the obligations which the parties have internally agreed.
Correct.
Now, thereafter, this agreement had not seen the light of the day because they have terminated it.
Correct.
So, therefore, today I am trying to say that so far as this agreement is concerned, since it is an offer has come from him, and I have accepted it and altered my position and have gone ahead, you are compelled to now sign the agreement. Now, the issue is until this agreement is not signed, these terms and conditions are not binding either on him or on me unless the court says that if he cannot walk out of this. Your lordship will have to be satisfied that so far as these terms and conditions are concerned, I am entitled to specific performance of this because of the simple reason this offer has come to him which is now backing out. I am trying to stop him from backing out of it.
So specific performance, the arbitrator can also pass.
No, I'm not on the question of specific performance arbitrator being passed. Yes, it can. Millard, it is as But thing is this, Millard, there has to be a valid binding arbitration agreement.
Again, you are relying upon.
I am relying upon
the suit. Your suit based upon the BTA. You relying upon the agreement. You prayed for the specific performance. In the agreement, there is arbitration clause. So why the court can enter into him if there is an arbitration clause?
Probably we are at cross purposes. An agreement is under proposal and acceptance under section 2 of the Contract Act. I propose, he accepts. If it is enforceable by law, it becomes a contract. That is well settled. Arbitration agreement is a dispute resolution agreement embedded in that agreement. If the parent agreement is not signed, and the arbitration agreement says that the parent agreement is not signed, then there is no concluded parent agreement. Arbitration clause says that any dispute arising under that parent agreement would be governed by arbitration. If today, my lord, he had signed the dotted lines and there was an agreement, and thereafter he doesn't pay, or he refuses to perform, then, your lord, I would be bound by the arbitration agreement because the parent agreement has come into force. There is no parent agreement today because he's walked out of it without accepting it. His proposal, he is not accepting it today. So, my lord, with utmost respect, if I may ask myself this question, I am relying upon those terms to compel him to sign to come into an agreement. To come into an agreement. I can ask for specific performance. Suppose today, my lord, he had not paid 72 lakhs, he would have paid 5 lakhs and said, good, I am not going to pay you anymore. But there is an agreement between him and me which says 72 lakhs is to be paid. I can go to arbitration and say that there is an agreement between him and me to pay 72 lakhs. Therefore, he is compelled to pay. Vice versa, if I don't transfer my licenses to him, he can come and say that there is a binding agreement between us, who both of us have signed the dotted lines. So therefore, these clauses in the agreement are binding on him. Today we are in a situation, he says that the clauses are not binding on me because the agreement was ultimately not signed and it has expired. I am saying that no, the agreement is not expired. I can compel you to sign, for which I have come to court. Today, my lord, there is no concluded contract between the parties. There is an offer and there is a counter offer.
If it is not a concluded contract, how the specific performance?
That is, my lord, something which your lordship might ultimately come in the suit and say that I may not give you specific performance because there is no concluded contract. But, my lord, that is where, my lord, I will have to show to your lordship that on the basis of your offer, I have altered my position in such a manner that I can compel you to sign the dotted lines because I have performed my obligation. Same in the case of agreement for sale and conveyance. I have paid you the money. You are now refusing to sign. Suppose, my lord, I agree to sell, somebody agrees to purchase. I have paid him half the money and ready and willing to pay the balance. And he is refusing to sign. So, my lord, your lordship will step in and said that he has performed his obligations. You have accepted his performance. So now you sign. You cannot walk out of the agreement. So therefore,
take it otherwise. What you stated that it if the court finds this, he has
altered disposition.
Altered disposition. Take otherwise. Now you are telling that it is not signed by the defendant. No, admitted, but as per the law. And if we'll say, then you have acted upon the terms and condition and you want that the agreement is to be enforced.
Yes.
Correct. If that so, you are admitting that agreement.
I am admitting that.
You are admitting the agreement.
Yes.
And you are telling.
No, here, my lord, your lordship is here. Probably I am not being able to express myself. I am admitting that you had agreed to enter into an agreement with me. And I am admitting the fact that you had agreed to purchase a store for me. I am admitting that this was the consideration amount. I am not saying had it been, my lord, an agreement had already come into force, I would have not sued him for specific performance. I would have sued him for, my lord, recovery of money, which I have done in respect of the first store, because he has taken it for 10 lakhs and has paid me 7.5 lakhs. There I have asked for money claim. I have not asked for specific performance because the agreement has come into being. So far as this is concerned, this BTA, what is all troubling your lordship is I am relying upon 5 printed pages containing the terms named BTA. If I am relying on it, do I admit that there is an agreement or not?
Correct.
This is all that is troubling your lordship.
Correct.
My lord, agreement, my lord, with respect, has to be on the basis of an offer and acceptance. There is no acceptance from my learner friend's side.
No, they have offered you and you accepted and you signed.
Yes. So therefore,
offer from them by giving the draft to you and you have signed and sent back to him. Might be he not signed. Subsequently, the communications Subsequently, the communication as per section 7 of 7BC.
That will not, your lordship.
If it is a
Because I have
communication,
not come to that portion as yet.
if it is a communication, so it
It's
cannot.
not, because that communication, if your lordship sees 7.3 and 7.4, my lord, 7.3 says that the arbitration agreement has to be in writing.
Correct.
It doesn't say it has to be signed. What is in writing is 7.4. Now 7.4, there are three alternatives given. One is it is signed. Second is it may not be signed, but the existence of the arbitration agreement is admitted in exchange of letters and communication, not the agreement.
No,
With respect.
no. Sorry.
I stand corrected. Obviously, my lord. I'm here to get corrected from your lordship. An arbitration agreement shall be in writing.
Correct.
No problem. An arbitration agreement is in writing if it is contained A, in a document signed by the parties. It is not here. An exchange of letters, telex, telegrams, or other means of telecommunication in which provide a record of the agreement. By agreement means this section is talking of the arbitration agreement. It is not talking of the parent agreement.
Correct. Arbitration
So
agreement.
therefore, none of these telex, telegraphs say that, look, there is an arbitration agreement between you and me. So therefore, what this section says is that it need not be signed. But if you agree in writing that, yes, I write to you that so far as this dispute is concerned, let us go to arbitration. I may not have signed the dotted line. I said, very well, let's go to arbitration. Then, my lord, the reference to that arbitration agreement is in telex where he accepts and I accept. It's all consensus. And the third is statement of claim and defense, which does not appear. This agreement, which your lordship is looking at, record of the agreement means record of the agreement to refer the parties to arbitration. That, with respect, my lord, is probably not by referring to the original BTA.
Okay.
That is my humble understanding, my lord. If my lord, your lordship wants, my lord, I can try and assist your lordship on that. That this agreement referred to in 4B means reference to the arbitration agreement, not the other agreement in which the arbitration agreement, because the Arbitration Act does not deal with the other agreement. Arbitration Act only deals with arbitration agreements.
Correct. Arbitration agreement means the agreement contains the arbitration clause. Contains the arbitration clause. It cannot be said that the arbitration agreement should be separate and agreement should be separate. If the agreement,
subject to correction, kindly see the definition of 2B. Definition of arbitration agreement.
section 7.
So section 7 only relates to arbitration agreement, not the bigger agreement which contains the intent.
That's why, please.
I'm sorry.
No, that's why. No, I am asking the question to you. Arbitration agreement called, what is the agreement? If the agreement contains the arbitration clause. The arbitration agreement cannot be, there is a separate agreement, there one another agreement which contains only for the arbitration.
That is a separate arbitration agreement, dehots the main agreement. Possible?
That is different thing.
Or two separate agreements merged in one.
Merged in one. Or only one agreement contains the arbitration clause.
Yes, separate. That's a separate agreement.
Correct. One agreement contains the arbitration clause. That is also an arbitration agreement.
Yes.
So here the BTA contains, it is not the BTA, this part is separate and this part is separate. The clause, what is the clause? 14.7. 14 is continuation of the BTA.
Yes.
So it cannot be said that it is not a arbitration agreement. So how you differ? Yes, no, this is not an arbitration agreement. Arbitration agreement should be a separate. It is not covered under the 743, 74C, B.
With respect, my lord, may I just try and read along with your lordship the way your lordship is now interpreting. an arbitration agreement may be in the form of an arbitration clause in a contract.
Yes.
Or in a separate agreement.
Correct.
So an arbitration agreement may in the form of an arbitration clause
In a
in
contract.
a contract. So the legislature has categorically made use of the two words.
Correct.
One is an arbitration agreement, which he has defined in 2B. Contract is not defined under the Act. So therefore, all subsection 2 says that if it is an arbitration agreement, it can be by way of a separate agreement signed by the parties, or it can form part of a contract. Arbitration agreement forming part of a contract, which is the case over here.
Correct.
An arbitration agreement shall be in writing, no issues. When it will be construed to be in writing? When it is a document signed by the parties, not here. An exchange of letters, telex, telegram, or other means of telecommunication, including communication through electronic mails, which provide a record of the agreement, not the contract.
Okay.
So the legislature, in its wisdom,
Yes.
has very distinctly used and defined arbitration agreement to mean an arbitration agreement in 7.
Yes.
Exchange of letters and communication referring to the arbitration agreement is one of the modes.
Correct.
If it refers to the contract which contains an arbitration agreement, that would not be construed that I am also accepting it. For example, let us take the case over here. I am saying, I am communicating with him as regards the disputes. He is saying that no, this is there, you have not done this, you have not done that. These letters are being exchanged. In the underlying, there is a contract of arbitration. The purpose of this section, if I have understood it correctly, Milord, is to Milord, if the legislature wants that there should be an agreement, there has to be meeting of two minds and conscious meeting of two minds. Your Lordship sees A, B, and C, they only substantiate that these are the known legal modes of a conscious meeting of a legal mind. Yeah. One is, yes, you have signed. Your conscious decision, positive act, that. Second is a reference to an arbitration. Even, Milord, under this, Milord, letters, there may not be an agreement at all for arbitration. Possible that there is an agreement.
Yes,
that dispute be possible.
I agree. Yes.
And I write to him, let us go to arbitration.
That's enough.
And he says, yes, let us go to arbitration.
That is enough.
So it has to be an exchange. So meeting of minds as to arbitration. And third is, I file a statement of claim before an arbitrator, and you, without taking an objection as to the jurisdiction of the arbitrator, you go and say submit to his jurisdiction. So this conscious meeting of minds is what subsection 7(4) in my respectful submission subject to correction is trying to hint at. What my learned friend is trying to impress upon your Lordship is that, look, we have written letters to him. And I have referred to the BTA, which is the contract in subsection 2. So very well you have. I'm not saying that there was no correspondence, or I'm not denying the existence of BTA. So that does not mean that by implication, since that BTA had a clause which you had not signed, and I have also, so where is that meeting? That look, in that BTA which we are now discussing, the terms and conditions, that contains an arbitration clause which is not signed by me. But are you ready to go to arbitration? Or I said, yes, let's go to arbitration and finish it off. That meeting of mind by letters, telex, correspondence is not here.
Yes.
So merely by referring to the contract, your Lordship is troubled with the presumption that you know the BTA contains an arbitration clause. So you are aware of it. So your Lordship is looking at my implied knowledge.
Correct.
Of the fact, my implied knowledge of the fact that there is an arbitration. But
implied knowledge, and you have harping upon the BTA.
Yes, but the fact remains that so far as the requirement of law is concerned, That is not here.
That we consider.
Yes,
That we
your lordship.
consider. That we consider.
Now, my lord, coming back to the fraud.
How much time? 3:10. You will take for
Give me 15 minutes any day, except 20th, 21st.
census.
My lord keeps it on 24th. Then we have another matter similar.
24th of this month.
24th ही बोली तो.
What time? Census and suffering for the plaintiff. Census and suffering for the defendant. Defendant has concluded his argument in connection with GA2 of 2024 for referring the parties to the arbitration. Solicitor counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Solicitor. This is the matter. 25th March at 3:45.
My lord, can it be kept on 24th? Because there is another matter.
24th खाली है.
24th खाली. Oh, then let it be 20.
Because it is a fix otherwise. The interim order is still today.
Till 11th.
Counsel for the plaintiff submit the interim order is going to be expired in 11th of March 2025 and date for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier, which is going to be expired on 11th of March 2025, is extended till 28th of March 2025 or until
Why not this be kept as part of it?
I have no objection. I have.
as part of.
Grateful man.
Obliged.
कौन है? Witness है? Yes. Yeah. अरे उसको भेजो कोई पानी डालेगा.
Lord, I am to cross-examine.
Chief completed?
Yes, my lord. My learned friend was to begin his cross-examination, but then the witness had gone down, so my lord said, let's do it the next day.
What is your name, sir? Manish Bagri. MANISHBAGRI.
कोई आएगा लेने. उसको देखो नाम नहीं है कुछ. उसको लेगा ही नहीं.
Slowly.
कहाँ छोड़ के गया?
Yes, yes. But they cannot take it down properly.
उसको परितोषिनों को मैसेज कर दो लैपटॉप.
Has he taken his oath?
परितोषिनों को बोल तो.
He knows, right? He has to say the truth.
We are
Yes. Continue.
What's your occupation?
I am the partner's son in GH Industrial Corporation.
Sorry?
I have the business GH Industrial Corporation.
You have a business? Ki bolo answer ta ki?
I am having the business of JH Industrial Corporation.
Is this a proprietorship concern?
No,
What kind of an entity is this?
it's a partnership firm.
Who are the partners of this firm?
There are 4 different partners. 2 are private limited companies. One is Murlidhar Bagri.
Slowly, sir.
Let the answers go in. The stenographer needs to record.
One is
There are 4 different partners. Partners who are the private companies.
one
Ah.
is
One is Mr. Murlidhar Bagri
Mr. Murlidhar Bagri
and Mr. Rajesh Sabu.
and Mr. Rajesh Shahu.
Sahuni, Sabu, SABOO.
SABOO.
ऐसे BOO.
चारटे बोले ना, 4 partners, right?
4 partners.
What about the other 2 partners?
These are two are private limited companies.
2 are the private limited company, 2 are the persons.
Could you please name the private limited companies?
HA Holdings Private Limited, HA Enterprises Private Limited.
Holdings Private Limited and HA
Enterprises Private Limited.
Private Limited. Sir, go slow.
Enterprises Private Limited.
So I take it that you're not a partner of this firm.
No.
In what capacity are you deposing before this honorable court?
I have been authorized by the partners.
I have been authorized by the partners.
Which of the partners have authorized you?
My father is Mr. Muralidhar Bagdi and Mr. Rajesh Sabu has authorized me.
And Mr. Rajesh Sabu has authorized me.
And in the authorization, all the 4 partners have signed.
And in the authorization letter, all the 4 partners have signed. All the 4 partners have signed. Sir, kindly go slow.
Is this authorization letter a part of the records of this case?
Pardon me?
Is the authorization letter a part of the records of this case?
Yes.
Can you point out where, please?
Show me the documents.
Yes, you may have a look.
Exhibit the. अरे लिस्ट था ये how we can
জাজেস ব্রিফে হবে হতে পারে যদি হয়
It is written over here also.
Yeah.
This is the affidavit under section 65B.
No, it is through court. It is the specific case of the question from the advocate. Have you filed the authorization given by the partners to you?
To depose in this matter.
I have given it to my lawyer.
Yes. Yes, next.
Can you produce a copy of the authorization on the next date?
Yes.
Please do. Who signed this authorization on behalf of the 2 partner companies?
Mr. Rajesh Sabu.
Mr. Rajesh Sabu.
He is the director of both the companies.
He is the director of both the companies.
Did he have an authority to sign on behalf of both the companies?
I can't recall.
I cannot recall.
Can you check and get back on the next date?
Yes.
Can you also produce?
Who will give him the authority?
I don't. How do I know?
He is the partner of the company. He is
Sir,
having the
you
major
cannot put
stakeholder.
the question. You have given the answer. Yes. So you have to ascertain from your company.
Okay.
You cannot put the question to the advocate.
I'll get
Only if the question is put to you, you are not understanding the question, you can ask for repeat the question.
Okay.
কি গেল কোয়েশ্চেনটা কি গেল
Can you check the get back on that?
কিসের জন্য বললাম
আগের প্রশ্ন বলো তো
But he have authority to send on behalf of both the companies.
Did he have correct
Both the companies. I cannot recall.
I cannot recall.
Can you check? Check and get back on the next day.
Next date. হ্যাঁ উনি বলেন yes. Can you also produce the document by which Mr. Sabu was authorized by the two partner companies?
I have to check.
I have to check. I have to check. Please do and get back on the next date.
Yes.
Why have you filed this suit?
Can you elaborate your question?
Why you have filed this?
Why have you filed this suit?
Because I have not received the payment of the material which I have supplied.
Because I have not received the payments of the materials I have supplied. Just slowly. Please.
What materials are you referring to?
These are HR plates, iron and steel material.
The HR plates,
You can write it in bracket iron and steel.
iron and steel.
HR plates, bracket A, iron and steel. Are you involved in the manufacturing of these materials?
No.
Then how do you supply such material to your customers?
We purchase it from Steel Authority of India Limited.
We purchase it from the Steel Authority of India
Limited.
Limited. India Limited.
And resell it to our customers.
And resell it to other customers. Right?
Do you first receive orders from customers or first? Do you first receive orders from customers and then subsequent and then thereafter place orders to the Steel Authority of India, or vice versa?
Vice versa. The products we purchase it in bulk, and then we keep it in our godown.
We keep it in our the product we purchase is in bulk. We retain it in our godowns. Yes, sir.
And then supply to various customers according to their orders.
And supply it to various customers
As per their orders.
for their orders.
So is it your evidence that the products lie in your godown irrespective of whether there is an order or not from a customer?
Yes.
What quantity of material are you claiming to supply?
I need to see the document.
Allow করে দিন.
Invoice.
He wants to see the. You can, if you want to see the document, you can take the learned judge's permission.
I want to see the invoice.
May I see the invoice and then you'll be allowed.
Show the exhibits. Show the invoices.
Judge's brief টা দিয়ে দিন, উনি দেখে নেবেন. Are you claiming to supply? Are you claiming to have supplied of it?
Judge's brief of document दीजिए कहाँ है? Shown to him. He will identify the document.
There are two different types of plates. One is
There are two different type of plates. One is
8 ton 80 kgs
8 ton 80 kgs.
and the other one is 3 tons 820 kgs.
3 tons 820 kgs.
Exhibit दो.
Exhibit marking করা নাই.
Yes.
Does the invoice specify the quality of the product?
No.
Are you competent to comment on the quality of the product?
We have issued test certificates along with the products.
Along with the products.
Who did the testing?
Steel Authority of India Limited.
Steel Authority of India Limited.
When was this testing done?
I can't recall.
I cannot recall.
Was the testing done in your presence?
I cannot recall.
Have you ever participated in any testing done by Steel Authority of India in respect of any product supplied to you?
Yes. To you.
Yes.
Please point out for the testing of which product were you present?
That may not be possible.
That may not be possible.
That may not be possible.
So I take it that you have no memory of remaining present during testing of the products which you have referred to in the invoices.
That may be 30 years back, so I don't remember.
Yeah. So I do not remember. So I do not remember.
When did you make, when do you claim to have supplied materials to the defendant?
May I see the...
No. The cost.
I cannot recall.
I cannot recall.
Which year?
I cannot recall.
But the testing, but it is correct. But is it correct? ঠিক আছে, ছেড়ে দিন। 30 years বললো না, ঠিক আছে, ছেড়ে দিন। Would I be correct if I said that you know nothing about the physical attributes, physical and scientific attributes of the products in question?
Please repeat your question.
Repeat করে দিন।
About the physically and scientific.
Physical
and
scientific
of the product in question.
No, you are not correct.
What do you know about this product?
I know, I can tell you about the thickness of the product.
Not,
I can tell you about the thickness of the product.
I am clarifying that I do not wish to know about the dimensions which any layman can measure. I wish to know about the quality of the product.
That is written in the test certificates provided by Steel Authority of India Limited.
Provided by
Steel Authority of India Limited.
Authority of India Limited. So use the microphone.
Do you even operate from your warehouse? But go down, sorry. Do you even operate from your go down?
You mean me?
Yes.
No, my go down in charge is there. My go down in charge is there.
So is it correct that whatever transpires in your go down is not witnessed by you personally.
I sell
Is not witnessed by you personally.
I sell a huge quantity of materials every day. So it is not necessary I check all the materials personally.
Check all the materials personally.
But do you check materials personally on a daily basis? Materials personally on a daily basis?
No, weekly. Not daily.
Weekly.
Once or twice in a week.
Weekly, once or twice in a week.
In a week.
And how often does your go down dispatch materials?
Almost every day.
Is it several times a day, often?
Sir, what is your case?
My lord, I will come around.
Sorry.
I will kindly just allow me 1 or 2 more minutes. Okay. I'll change my line of questioning. Last question, Taki Golo. Once or twice a week.
Yes, once or twice a week.
Whom were you interacting with from the defendant company?
We were interacting with the director and his commission agent, both.
Director and his commission agent.
By what means were you by what means of communication were you interacting? Were you interacting?
Telephonic talks and personal talks. Individual, face to face.
Did the Can you name the persons with whom you were interacting?
The director of the company.
Name the I repeat current question. Don't name their designation. What I'm trying to say is that if you can name those humans.
Mr. Mimani and his consignment agent, or you can say commission agent, Mr. Kamal Jain. Kamal, Kamal Jain. Mr. Mimani, Director of Surya Electrical and Engineers Private Limited.
Mimani, M-I-N.
M-A-N-I.
Yeah.
What was Mr. Jain's role in the alleged transaction?
He is the middleman between the transaction.
He is the middleman in the transaction. Yes, next.
Why did you not implead him in this suit? Why did you not implead him in this suit?
I cannot recall.
Where were meetings held between you, Mr. Jain, and Mr. Mimani?
During this transaction, it was a telephonic call.
Have there been other transactions with between the plaintiff and the defendant?
Yes, there are several transactions earlier.
There were several transactions earlier.
So the alleged transaction forming part of the instant case is the last transaction. Am I correct?
Yes.
Whose telephonic call did you receive?
Mr. Kamal Jain.
In connection with this transaction?
Mr. Kamal Jain. Later he took, I can't recall, but later he took Mr. Memani in conference.
I cannot recall properly, but later he took Mr. Mimani in the conference. Calling.
Telephonic conference.
Telephonic.
Were you using your landline phone or mobile phone?
Mobile phone. And it was on speaker.
Mobile phone, and it was on speaker.
What was your mobile number?
98300
Slowly. 98
300
300
39787.
39787.
87.
Can you produce that phone if required for
Yes.
inspection?
Yes.
Produce the phone if required. Answer is yes.
You can. Yes, I can.
Yes. Yes, I can.
On a later date.
Right. On a later date. On a later. Why were you? Lord, somebody has come behind your lordship. Yes.
Person who is supposed to come has come.
Like a side screen, my lord, while a batsman is batting, somebody walks past the side screen, my lord, the batsman, my lord, turns away. Similar, my lord. It's always when the moment, my lord, somebody comes behind, my lord, the bowler, it's, my lord, a little nervous then to proceed with the matter. Okay.
On a lighter note, I have observed one senior rightly told me when I was 3 or 4 years into the profession. I believe it's late lamented Mr. Pratap Chatterjee that, and pardon me for using Bengali, he said, আমরা কিন্তু জজের আড়দালিকে দেখে দাঁড়াই আর জজকে দেখে বসে পড়ি. And that is so true. Sometimes it's true. We see them coming first. We all stand. By the time your lordship think we all sit. Well,
Okay. Lord, may I stop here today?
Record. उतर जाइए.
Thank you.
Sense and suffering for the plaintiff. Sense and suffering for the defendant. Plaintiff witness is present. Cross-examination resumed. But due to paucity of time, cross-examination could not be concluded. Accordingly, cross is deferred. Let the matter appear 9 June at 2 p.m.
Malad, may I mention serial number 28? Malad, my matter was filed under section 8 of arbitration, and senior counsel Ratnako Banerjee has argued partially the matter. Malad, if Malad may place the matter for argument after 18th of March, any day, Malad.
Let it be in the list, madam. This is only for the not mentioning time, only the interim order extension. Yes.
Interim order extension, I believe my learned junior mentioned, my lord, since we have been waiting patiently, my lord, pay item number 38. I've given also notice to the
38
bank
of today's
today's list, my lord. But I've also given.
Which for the defendant?
My lord, one bank has appeared. My lord will recall the last. The Bangladeshi bank has appeared. I have given her notice. Whoever has appeared.
Suffering for the plaintiff, suffering for the defendant number 2. Counsel for the plaintiff submitted the interim order granted earlier is going to expire today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 8th of April 2025 or until further order, whichever is earlier. Let the matter remain in the list.